Where you to mention senior citizen matter, I serve the notice others.
Today is not mentioning day.
Kindly
Mentioning day on first day. If you allow any.
Yesterday is not possible.
Huh?
Yesterday was date was.
First day. नहीं नहीं हो गया कि सीनियर सिटीजन मैटर नहीं
I was listed motion. Only listed
listed motion
motion for
motion give the slip no hearing what is the urgency
motion for
mere service of notice not satisfaction of regarding energy urgency is required
your lordship directed to matter to appear my lord.
It is the urgency only when it will returnable matter এটা আছে কিনা দেখবেন তো একটা hearing
Under extreme urgency may be permitted to mention. This is a hearing matter, my lord. The petitioner is a old lady of around 84 years of age. She is devoid of land compensation. She is not getting it. It's a hearing matter. Kindly.
Devoid showing your age. Petition of which year?
2022.
2022. I don't believe you. Senior
It has
citizen
been
matter.
served to the other side, my lord.
I have one matter, my lord, appearing in the monthly list, my lord. It is very urgent, my lord. My house is situated upon the bank of a pond. The pond has been excavated and my lord, it has been leaned towards the pond, my lord. It has been done by the panchayat.
You constructed your house on the bank of the pond.
My lord,
West Bengal Inlet Fisheries Act does not permit.
No. I have constructed upon the Vastu land. But my lord, besides my pond, besides my house.
Okay, upgraded matter. Yes, call the list. Item number 1. For judgment, item number 1.
Item number 1 for judgment.
Yes. Therefore, based on the discussion and reasons set out in the preceding paragraph, the memorandum of charge sheet dated 29th August 2013, the inquiry report, the order of the punishment issued by the disciplinary authority dated 28th September 2013, and the order of the appellate authority dated 31st December 2014 are hereby set aside. The respondent bank is directed to disburse all admissible terminal benefits to the petitioner, treating the case as if no disciplinary proceedings had been initiated against him. পাঠিয়ে দেবেন অন্য পাতাগুলো সই করা হয়
Item number 2 for judgment.
I'm for the petitioner.
In view of the discussion and reasons set forth in the preceding paragraph, the respondent number 3 is directed to approve the appointment of the petitioner number 1 to 4 to the post of teacher and petitioner number 5 to the post of non-teaching staffs of the schools with effect from the date on which the financial aid was granted to the school. The respondent number 3 shall also release all consequential benefits, including arrears of salary and retirement benefits, if found admissible. The entire exercise shall be completed within a period of 8 weeks from the date of receipt of a copy of this order. Respondent number 1 and 2 shall ensure that the respondent number 3 complies with this order in its letter and spirit within the time frame stipulated herein. Next.
Item number 3.
My lord, in item number 3, Mohammad Sarojan is appearing on behalf of the institution, my lord. And he is suffering fever, my lord. Pray for not this week.
You are still insisting on correction.
Still insisting on correction, my lord. He had certain points to oppose.
Yes, ma'am.
My lord would kindly keep it on 20.
He is saying that it is not a technical post.
My lord.
It is a non-technical post. So here UGC is the authority to assess whether you have requisite qualification or not for the post.
Perhaps Mr. Basu, who was leading me, my lord, was able to satisfy my lord as to the applicability of the UGC norms.
Okay, come tomorrow.
No, my lord. Not
He is
this week.
suffering from
He's
fever.
Not
suffering-
this week.
28th or 29, if I may.
Okay, not this week, not this week.
Grateful, man.
Yes, Gautam Sarkar, what happened?
Item number 4, I am for the petitioner. My lord, it is a land matter and the determination to take this matter upon the honorable
The matter
justice.
matter stand released from my list due to want of determination.
Grateful, my lord.
কিন্তু আমার তো determination আছে। But it is a hearing matter of 2024.
Yes, my lord. Motion matter.
হ্যাঁ, irrespective of classification, আমার তো determination আছে, তাহলে want of determination আছে।
I have mentioned it,
So-
code number 9, but
Oh.
mistakenly come in this code.
Oh. Whether this bench substantially heard this matter?
And
সেটাই ও ওইখানে করতে চায়, কেটে দিন তাহলে want of determinationটা কেটে দিন। হ্যাঁ, has determination to hear this matter. Now you want to get the matter heard out by another bench. Huh?
I mentioned it before code number
তাহলে
9.
want of আরে তাহলে কি কেটে দিন। আচ্ছা, আপনি এটা কোনো গ্রাউন্ড হলো?
Only 5 minutes pass over. He will be here.
Not today.
Not today. Yeah, he's on his legs only.
Not today, not today. Huh? Yes, next.
6.
What, 7?
Item number 6.
6, I am for the petitioner, lordship.
Item number 6, madam, I'm playing for short passover, madam, learned ASD.
Lalit?
SC.
Oh. What do you want?
I pray for my representation pending before the authority, my lord. Authority, my lord, kindly come to page 16. This application should be considered by the said authority, my lord. Respondent number 3. I pray for respondent number 3. We will consider the my representation pending before him.
Deputy Secretary, Government of West Bengal, Department of Home.
Department of Home, the full method, it is a method. They have jurisdiction regarding freedom fighter concern, my lord. Earlier passed this order, my lord, in connection with similar case, my lord. The said respondent, my lord, heard the matter and considered the case.
Who considered your matter?
Earlier, respondent number 3.
No, earlier occasion you made
Earlier
application.
occasion, my lord, order was passed, my lord, direction to the said authority he heard the matter and considered this case, my lord. Consider when either consider or rejected.
Your husband died in 1977.
77 leads.
So
He was a renowned
you are
freedom fighter.
coming now.
Lordship, there is a, my lord, certificate issued by the renowned freedom fighter. Renowned freedom fighter. There is a notification, my lord. The notification with not with me, my lord. Notification whether the renowned freedom fighter certified any person, the government will consider. Who is the eligible, my lord, certifier?
Yes, Mr. 22, and you have filed it.
Yes. Lord, the question is that freedom fighters pension scheme is not a statutory right under Article 309. It is a scheme. Now, the scheme provides that if a freedom fighter makes an application for pension and before getting the pension he dies, no other dependent shall be entitled to get any pension unless he gets pension during his lifetime. The scheme itself says this. I'm handing over this. Number one. Number two is that A. Lordship has rightly pointed out that husband died on 1st September 77. And an affidavit has been affirmed with the petitioner on 25th July 2011. The Supreme Court's judgment in the Constitutional Bench judgment says that although in 226 no limitation applies, but explanation has to be given.
Has
And
to
that
be given.
apart,
Yes, yes.
and that apart, Article 137 will apply, 3 years. Number two. Number three is, Supreme Court has also said, I have a judgment, that court will be very slow to grant freedom fighters pension. Now, my lord, I first telling your lordship about the guideline about grant of pension. This is clause 5 and 1.5. Clause 5 says, I'm reading, I'm handing over then. Sanctioning the dependent pension to spouse or daughters of freedom fighter. Dependent pension shall be sanctioned to the spouse or unmarried daughter only if their names were appearing in the original application form submitted by the freedom fighter or the sanction letter issued by the ministry. Therefore, it is not the case here now. No, nothing is mentioned. Then, if the freedom fighter marries or has a daughter, either own or adopted, after the sanction of the pension, then family pension to such spouse or daughter shall not be admissible. Now, my lord, kindly allow me to place 1.5 of the scheme. Sanction of pension after the death of freedom fighter. No pension shall be sanctioned in the name of the freedom fighter after his her death, even if his her matter was under examination. This is exactly the case here. This also entails that no lifetime arrears or dependent pension shall be sanctioned to his or spouse, daughter, after the death of the freedom fighter. Kindly first peruse, my lord, 1.5 scheme.
My lord, I want this, my lord. And exchange of, my lord, the affidavit, my
No
lord.
question of affidavit. First of all,
Affidavit
it has to be admitted, whether it has at all to be admitted.
There is a, my lord, a
1.5
notification.
kindly see.
I am entitled.
This is exactly the same case here. The predecessor in interest of the petitioner did not get any pension during his lifetime. He died on 1st September 77. On this code only, the writ petition will fail. And then kindly come to the other clauses. The affidavit has been affirmed by the petitioner on 25th July 2011. No explanation of 13 years plus 11 years, that is 34 years after that, he filed an application here.
No, and that you said, oh, dependent pensioner and
1.5.
5 and 5.
1.5 and 5. Kindly peruse 1.5 first. Possibly the first or second page.
I will show, my lord, that I have right, my lord.
Okay. Asu.
My lord,
My lord,
Constitution bench judgment should I refer?
Yes,
my lord,
yes, yes.
my lord, one
This
thing
is-
I pray, they give the some time, my lord, for affidavit in he will be file a opposition and
No
reply.
function of affidavit.
Otherwise, it will be how it will be solved. He is showing that I have some documents, my lord. The government
Para
issued the
21 of the
notification.
Constitution bench judgment, delay in filing writ petition.
I will.
Oh, delay in the filing, that is it.
Para
So-
21 of the Constitution bench judgment.
Showing I have nothing in any documents, my lord, today.
Okay, acha.
Otherwise, my lord,
I appear for the petitioner, my lord. But pursuant to your lordship order, my lord, I have forwarded a copy of the writ petition to my learned friend, my lord.
And whom
Yes, my lord,
you received the
opinion, my lord.
license, we accept the license fee from the petitioner. Honor from what license?
Lord, the
Is it directly
petitioner,
the
your
response-
lordship, was a licensed porter with the Eastern Railway under
Oh, license
Porter.
porter.
Lord, the license will appear at page 10 of the writ petition, my lord. What has happened, my lord, from 2013?
He's serving as railway porter.
He was serving as railway porter, my lord.
Oh, in
from
which
the
station? On which?
Eastern region, my lord, the Eastern Railway, Howrah.
Howrah.
My lord, in 2013, my lord, the payment was not made. Accordingly, back was taken back by the, my lord, the railways. The reasons for, my lord, the petitioner, my lord, went to, my lord, become a monk in during that time, and that is why he, my lord, was not available, and that is the reason is such that he could not deposit the fees. In 2018, my lord, his father died. After that, my lord, the entire responsibility of the family came back to, my lord, the petitioner, and still then, my lord, the petitioner is pursuing the railway to accept the license fee, back license fee, and return the badge so that he can, my lord, continue with his, my lord, profession as a port license porter. Paragraph 3 of the writ petition.
Father died.
That is, my lord, after that, he, my lord, came back and wanted to.
But actually, my lord, according to railway rules, my lord,
Take the mic here.
well, according to railway rules, my lord, if a person remains absent for 3 months, his license will be cancelled, my lord. And here, my lord, this case is he is absent for more than 12 years. And not only that, my lord, we have
You apply afresh.
My lord, there is no order, my lord, cancelling my license fees.
we have sent letters 2 times, my lord. Two letters have written came back with a remarks that no such person lives in this address, my lord. According to his address, my lord, at page 12. Here he has written his address, plus we have sent letters to that address. And both the letters came back.
When you wrote those two letters?
Yes, my lord. In the year 2022 and my lord, 24, my lord, 23, my lord. And this is the postal remarks. This is the postal remarks.
You know, 22
You wrote the letter
To this person and to this
to
address.
this person, that means to the porter,
Yes, my lord.
original porter.
Yes, my lord.
I am, my lord,
When your father died?
in 2018, my lord, I am not claiming that my father's license should be given to me. I was the original porter. In 2013, my lord will kindly see me paragraph 3, my lord. I could not pay because, my lord, he became a monk. His father was not a porter. The petitioner before your lordship was a porter, my lord. So, my lord, after his father's death, my lord, the family responsibility came in, my lord. He now wanted to, my lord, get back to his badge.
His father was also porter. No.
My lord, that I do not have instructions.
Oh, okay.
This, my lord will see, my lord, the badge.
Oh, so your father died means that. So you consider
He is absent for more than 12 years, my lord. According to rules, it is not permissible.
it was received on 1st December 2021.
Can you see F, rule F?
So he will, if you say think, or if according to you, there's such representation which was submitted in 2021 cannot be considered. So he will submit a fresh representation, fresh application. You consider
We have sent letters, but in that address, but he doesn't reside.
later when you to 22
Yes, the address. Which
later for affording an opportunity of hearing. Later for what purpose?
same address. Can you see page 12? Page 12.
my lord, he is referring a letter, my lord, saying, my lord, that he has read, but my lord will kindly see the content of the letter. I made a representation in 2021. After that, they say I have been terminated in 2022. My lord, after I filed the writ petition, now they are terminating. That's what I understand from the content of the letter. What my learned friend is saying that
Terminated terminated already.
Yes, my lord.
that
No-
that's
no-
their
no-
informing,
no
my lord,
such
after.
person in this address not known.
My lord, kindly
Not
see, my lord, the content of the letter.
So I can do one thing, you hand over the letter and you file a challenge the termination letter.
Yes, my lord. Will kindly detail, I will send it this address, my lord.
Why,
Huh?
my lord, let him serve a copy of this, my lord. He is relying on a document, my lord. May I just indicate, because what I find, my lord, from the letter on perusal, that my writ petition is of 2022. My
Yes.
lord, it's pending. He wrote the letter in December 2023 that saying that it has been terminated in 2022. Whereas my representation for taking the money, my lord, is 2021. So as on the date I made the application for taking money, my lord, there is no termination. That is what his letter says.
Okay, you file a fresh application,
No,
they will
may I, my lord?
revisit the issue and reconsider. Huh? Okay. Alleging inaction on the part of the concerned respondent in
file a report. Kindly give me a week's extension. By Monday, I'll file it. I tender apology, my fault, my lord.
Okay, Mr. Chakraborty, learned advocate, repenting the respondent prays for extension of
Petitioner, my lord, service, I am extremely sorry, I repeat, my lord, service is not ready. Done but in the form of affidavit. Just for this. I'll file it.
acha, acha, an accommodation had been sought for on the
For the petitioner, here interim order was passed initially on
I'm the
16th of
respondent.
December 2022. It will expire on,
Some development is
yes, some development is there. The petitioner was called for hearing before the West Bengal Transport Infrastructure Development Corporation, my lord.
so whether
give some
talks of settlement is still going on,
Still going on, my lord.
second page, lordship, kindly.
Decision
not matured as yet.
not matured, but to some extent it has.
Ah,
To some extent it has gone.
proceeded to some extent, but
Proceeded to some extent, but did not mature.
so I am again adjoining, and what was the আচ্ছা আপনি চলুন আচ্ছা
On issue regarding 15 years old vehicle is over.
আচ্ছা
Item number 12,
আচ্ছা আপনি এটা লিখে দিন তো লিবার্টি ইজ গ্রান্টেড টু দ্য পিটিশনার টু মেক ফেয়ার ফর প্রিপনমেন্ট অফ ডেট in the event in the meantime the matter is settled.
Extremely great.
Yes, yes, yes. You take the money. You are not audible.
Lord, I don't know why this is appearing.
Oh,
for-
low voice will not. Okay.
My lord, I'm appealing for the
Item number 12,
12 and 13. My
13, yes.
lord,
Lord,
as per my sorry,
bol, bol.
my lord, as per my lord's last direction, affidavits were supposed to be exchanged between the governing body and the principal of the college, concerned college. And my lord, here interim order has been extended till disposal.
Yes.
So
Lord,
it has come up under extension of interim order.
Lord, the principal is supporting the petitioner against the governing body. So principal has filed an affidavit. We have to deal with that. Now, they are temporary employees who have been, Lord, they say that they are sought to be terminated. They produced a governing body meeting. We said that that resolution has never been adopted. So the matter should have ended at that point of time. They are carrying on with the litigation. I don't know why. They come up with the writ petition saying that there is a resolution.
Their grievances have been redressed.
According to me, may I just get 2 minutes time? They relied on a notification saying that in terms of this notification, the managing committee is trying to terminate us. Apart from the merit of the matter, we said, the managing committee said, this sort of a resolution was never adopted.
Never?
Adopted.
Oh.
Then nothing survives in the matter. Now the principal somehow has a strained relation with the governing body. He is taking advantage of the litigation, bringing on issues which are not germane to the litigation. He has filed an affidavit. My lord gives a date for hearing of this matter. Whenever your lordship's diary permits, according to me, nothing survives in the matter. Mr. Kollol Bose's apprehension has been redressed. He says, I have tried to terminate him. I say there is no resolution. Then what your lordship will decide? Future. That is the endeavor which has been taken by them. See,
One report could have served the.
I have filed affidavit saying that. Take my affidavit.
Have you not filed a reply?
Yeah, filed.
Yes,
Reply filed.
my lord, the petitioner has filed their reply. On the last occasion, the principal of the college had filed because there was a dispute with regard to whether the resolution was at all undertaken or not. This was sought to be resolved via filing of an affidavit.
Not required.
Lord Justice Joy Sengupta had directed filing of an affidavit on behalf of the principal. The principal has now filed an affidavit. Now, as per my lord's last direction, the governing body is to reply to that affidavit. So, this is the current state of the matter. It is not merely an apprehension that my
But principal has taken a contrary stand.
Yes, but the governing body says no resolution. How the
Principal has taken a contrary stand.
there is a
Now principal has filed affidavit.
yes.
Have you filed reply there too?
No, a reply from my end might not be required.
Oh.
It is for the governing body to reply.
Now they want the fight between the principal and the governing body to be adjudicated. My lord will kindly take page 67 for a minute of the writ petition.
My lord,
I
was under instruction to seek time today. Because
That's
I'm not
whether government,
my lord fixes a date.
whether government governing body.
এক মিনিট লাগবে
Yes, yes.
67 once একবার আমি ব্যাপারটা বুঝিয়ে দিই পরের দিন করবি 67 of the writ petition.
I shall forget.
Just for a
Do it here and now.
just for a second. Come to page 67 of the writ petition.
এইটাই তো রিপিটিশন নাকি কোনটা?
মৌমিতা নস্করটা দিয়েছেন তো? হ্যাঁ 67 পাতা রিটেন।
They ultimately, the matter will not be taken up. So why?
Just page 67, my lord, is page 67.
That's
See at the top, 1st October 2024.
yes.
Lord, kindly come to agenda number 3 for a minute.
Yes, 3.
Principal reported that Moumita Noskar contractual non-teaching staff
Big resolution. You come to the
against Orpita Ghosh, come clerk, acting cashier, it has found that the letter addressed to principal dated so-and-so was there, whether a similar letter has been written. Considering all this, the inquiry committee was formed under the leadership of the Chinmoyi Chatterjee, leave proper inquiry, so-and-so, so-and-so. Then it was resolved that the services of all the contractual staff will be primarily terminated on and from 31st December 2024. This was under challenge. Now we filed an affidavit. In affidavit, we have said that this was discussed, no resolution was adopted. Managing committee is not going to adopt any such resolution. Then what is left?
So not
Take my affidavit, it's there. What is left there?
rather you say whether you are going to terminate them or not.
Lord, in future, suppose if they do something, if I give that, do you want that undertaking from me? Suppose if tomorrow they stop coming to college, I will not be able to do that then?
No, my lord.
It is for the managing committee to decide whether they want to do anything or not in the future. Today, my lord is deciding on this notice though. We had constituted a committee, no resolution was adopted, matter over. Now today what they want is that I should come and say that I will never do anything. Then that is really in perpetuity they want an order from the court. That cannot be done. My affidavit is very clear that we have not adopted any such resolution. It was deliberated, not adopted.
So at this stage, your purpose will serve.
Purpose also serve. There is no cause of action left. If tomorrow we do something legally, he can again come back. But this interim order, principal comes and says something, there will be an inquiry, fact-finding.
So you will not file your response to the affidavit filed by the principal?
Not that.
Not required.
What I am saying is, my lord, fix a date for hearing of the matter. In the meantime, if we can file a reply, we will file. Otherwise, my lord, decide the matter. Fix a date on a particular day, we will do it. Interim order is there till disposal.
My lord fixes a date.
Yes. My point is, today we come to court on a particular cause of action. If that cause of action doesn't survive, what the court will decide? Something which is in the air.
We have not adopted such resolution.
Achha. Yes, এই সবাইকার নাম লিখে। হ্যাঁ।
Matter number 14.
Well, the 14, I beg to appear on behalf of the petitioner.
14 ধরবেন, especially
Mala, this 14 is a very short matter. Mala,
Very
the
short
pension matter, my lords. Petitioner aged about 77 years.
77 years.
So now the, my lord, if your lordship kindly,
Why he has not getting pension?
my lord, I am coming. My lord, these people lordship.
What is the reason?
My lord, I am, if your lordship kindly go through the, my lord, this, I have prepared a list of dates. My lord, this,
Okay, you said the petitioner appointed at organizing groups is stopped. Whether his appointment was approved.
My lord, everything has been decided by this honorable court, my lord. I am coming, my lord, I am coming. If your lordship kindly go through this mother list of the dates, it will be held because of the this.
You give the
now, my lord, this
the petitioner was an organizing group staff, non-teaching staff.
No, I am shortcut, my lord. In my lord, the 2000, as per the order of this honorable high courts, the appointment of the petitioner was approved. My lord, approved on 10th of May 2000. Page 14.
Oh, 2000.
2000. So now there is the faction.
When he retired?
Mala, I am coming. Mala, it's a very shortcut because
you give the answer. You give the answer not in his your. Give the answer.
1st of October 2008.
That
I am
means
getting the pension.
That means 10 years, not completion of no.
No, I am getting the pension.
You are getting pension.
Yes, Mala, that's why Mala, I am
2008.
Yes. Now, but in that
only 8 years service.
Now, in the approval, the authority concerned has given notional benefit from the date of recognition of the school, that is 1st of May 1997.
Notional benefit.
1st of May 1997.
Yes.
Now the financial benefit was extended 1st of May 2000. So now notional benefit means I am entitled to get the all benefits relating to my the service period. Now that approval has been challenged by this petitioner before the Honorable Justice Barin Ghosh, then his lordship was. My Lord Justice Barin Ghosh held, no, since the date of approval of recognition of the school, the petitioner is entitled to get the financial benefits. Got it, my lord? Now some fake persons claiming themselves moved a writ petition before
some
the unknown persons,
outsiders
came before this honorable court, moved an application challenging our approval, which was granted pursuant to the order of this honorable court. So now an interim order was passed, my Lord Justice Kalyan Jyoti Sengupta, 1st of November 2003, thereby directing the authority concerned not to pay the salary of the persons whose appointment have been approved by the authority concerned. Now in the period, my lord, from the date of approval of my appointment till the interim order, our the salary has been already been paid.
Yes.
Thereafter interim order, since the interim order has been passed, our salary has been withheld.
Stop. Yes.
Stop. Now the matter came up for final hearing before the Honorable Justice Kalyan Jyoti Sengupta. So my Lord Justice held, Justice Kalyan Jyoti Sengupta on 14th of my Lord the January 2004. No order can be passed in this writ petition without disturbing our approval of appointment, which was granted on 10th of May 2000. Got it? By virtue of the interim order, our, my lord, the salary till my date of retirement withheld. Now taking into consideration of my service period,
I retired on 31st of October 2008. I am getting the pension. But this period, because of the 1st of May 1997 till the 30th of April 2000, that is the first part. Second part is this, by virtue of the interim order, till my date of retirement, this period, my lord, my salary has been withheld.
Okay.
Now,
So,
I am coming, then, my lord, what I have, my lord. Then the school de-recognized. De-recognized. My lord, what happened, my lord? Kindly see. Now, some existing, because of that, prior to that, I retired, I am getting the pension. Some of the existing teacher, my lord, transferred to the another school. And the joint secretary of the school education department directed the district inspector of the school to release the area salary which has been withheld by virtue of the interim order. Now, my lord, is kindly come to, there are 6 teachers which has been approval has been granted on 10th of May. 3 writ petition moved before the honorable court. My lord Justice, my lord Anuruddha Rai. My lord, if your lordship go through the, my lord, I am referring the persons whose name, whose appointment was, whose salary was withheld. Dhirobandhu Purkait kindly come to page 14. Petition? Oh, sorry. My lord, this serial number 4. Page 14, kindly come to.
yes, you state that thereafter you take me to the document.
Let's kindly come to Dhirobandhu Purkait.
Yes.
His salary also, this appointment, my name is kindly come to Lokhikanto Naya.
Lokhikanto Naya.
Yes, petitioner before your lordship. So now move this before this honorable court. Now the authority concerned has come to a report and affidavit submitted that since the interim order has been passed, my Lord Justice Kullanjyoti Sengupta, that's why their backward salary could not be released. My Lord Justice Anuruddha Rai, the interim order will match with the final order. They are entitled to get all the salary. From the date of the withholding till the date of joining the new school. Because Justice Sengupta's order, my lord, I have annexed. My lord, if your lordship.
No, you have not annexed.
Yes. My lord, I have.
Yes, I think
my lord, this kindly
to be passed except granting liberty to the petitioner to say such as may be advised in the fitness of the situation.
Your lordship kindly.
Okay. Now you show the order passed by the Justice Barin Ghosh.
My lord, this is a kindly relevant portion, page 25.
Barin Ghosh judgment.
Judgment, relevant portion I will not place because of that is the lengthy judgment.
Yeah. But 25 years, some cost item.
In my writ petition, my lord, is the judgment of
thereafter. Yeah, it is Justice Kullanjyoti Sengupta. Barin Ghosh. You know, properly 23. In view of that, the petition is partly allowed directing the district inspector of schools. And
the petitioner is partly allowed directing the district inspector of schools such and such to due in later 10th of May. That is
to
Malad,
To
the
his letter,
corridor,
before that, to his letter, before that,
Malad, the South Chobbish one issued approval of, to issue the coroner.
incorporating the organization in relation.
Financial benefit with
approval
effect
has
from
been
1st of
accorded
May.
by the said letter shall get financial with effect from such and such. Director is also
Now approval.
decided whether grant
Malad,
of
2 days is
approval of
very vital.
appointment
Malad, this,
of class 4 staffs in question within a period of.
Malad got it. Malad, now kindly, I am giving trouble.
No, the director of school education West Bengal is directed to decide whether to grant of approval of appointment of Siddheshwar Bhandari.
I am not
Oh,
Siddheshwar.
yeah, not. So the Justice Ghosh directed that
To extend the financial benefit.
they will get the salary from salary
Malad, kindly come to page, page 14.
to whom shall get financial benefit
First of
with
May.
effect from financial benefit with effect from such and such.
Now kindly come to page
So
14.
who is for the state?
For the statement.
So give it.
So Malad, this I Lordship kindly.
Okay, coordinate bench has passed this order.
My Lord, these are 2 coordinate bench. Very recently, my Lord Justice, my Lord Rai Chattopadhyay, 7th, taking into consideration of the Dinobandhu Purkai.
Dinobandhu Mukherjee, who are two.
Purkai, that is the serial number 4.
Latest judgment.
And this is the latest judgment. My Lord, these are both the judgment I have given to the Lordship. And my Lord, if your Lordship kindly go to the list of the date. My Lord, these are kindly come to, my Lord, go to the, my Lord, this is list of date. My Lord, may I place the my Lord Justice Unauthorized Rai
মামলা করব ফিক্স ম্যাটার আছে হবে could I seek one indulgence from your lordship? My lord has there is two fixed matters at 12:30.
Yes.
That other matters may be released till recess.
8:30. Okay, 12:30 দুটো ম্যাটার ছিল। Yes, who is appearing for 12:30 matter?
Item number 17, I am for the petitioner.
You are for the petitioner.
And
18 you are. Okay.
both the matters are other side are there.
Other matters accepting the 12:30 fixed.
Okay, one matter is going on, thereafter your matter will be.
No, not mine, but other matters.
Other
I'm in 15. The other matters may be released till recess.
Okay, we have 15 up to this session. Up to recess.
Up to recess release.
Up to recess. Yes.
Don't take me.
Okay.
I've disturbed your lord.
Okay. Up to recess, yes.
So, my Lord, this
No. It will be taken.
only, my Lord, I have come before your Lordship, my Lord Justice Chattopadhyay, by taking into consideration of the judgment of the Honorable Justice Unauthorized Rai.
Now you want salary and other benefit from the date of
only part of interest. My Lord Justice Chattopadhyay held interest from the date of my Lord this the judgment. But the without my Lord this part, I am placing before your Lordship against that order, my Lord, that part I prefer an appeal. Because of that, since your Lordship has considered,
you have preferred an appeal.
Only down interest from the date of entitlement that has been extended, my Lord Justice Unauthorized Rai. Interest from arrears salary from the date of entitlement. I am entitled because of the authority concerned withheld. That has been considered, held, and directed to the authority concerned to release the arrears salary along with 10% interest. My Lord Justice Chattopadhyay held, my Lord, this the 6%. So that part, my Lord.
For getting 4% more, you have paper appeal.
So, my Lord, this the petitioner had to. Now I have leave it to a Lordship.
Now we are seeking a direction for payment of interest.
That has been considered both the court. both the court. Area salary, both the court consider 10%, one court, another court 6%. So now I leave it to lordship as a banking rate.
No, if I give less than 10%, then another you will.
No. I give you the undertaking before your lordship, whatever the interest, without interest, I can accept.
Okay, Hardal advocate appearing for the petitioner lists the matter for under the heading for order sector. রেখে দিন তো অনেক fact আছে দেখতে হচ্ছে।
The list of the date.
আদিয়ার মাথায় ওদের ম্যাটারটা আছে। List of dates here. Under the heading for order. একটা
any short day, 77 years. He is suffering, he is in the completely bed rest. 77 years. 2008. Next week, any day.
Next week.
Kindly consider. For orders, your lordship will take the note and nothing. It will not, because of the I heard this matter 3 days before my Lord Justice Unauthorized Rai. 3 days. Then my Lord, the judgment has come to the final order.
Oh.
So that is, I have handed over before your lordship 2 judgments. My Lord Justice Chattopadhyay, the 7th of July, and that judgment passed by the Unauthorized Rai, 21st of May, 2023.
Yes.
Kindly consider. For orders, next week, my Lord. Dinobandhu.
Without interest, 2 coordinate bench has granted interest.
I leave it.
Have you prepared appeal?
No, they have not prepared appeal. That's so.
Against you prepared appeal, state. So.
My Lord, I 6% at least. That has been extended by coordinate.
6%
I undertake before your lordship that I will not take further step if your lordship extend the 6%, whatever order has been passed by my Lord Justice.
Okay, Hardal advocate list the matter for further.
I have before 30.
Yes.
29 I have no.
Yes. Yes.
My lord, the next matter, your lordship.
না সবাই দাঁড়িয়েছে আমাকে বেরতে দেবেন লাকি করে মার
15টা রাখুন তো
Hardal advocate appealing for the respective parties. They will take care of you. নাম দিলে হবে তারা যে বক্তব্য বলে দিতে হবে না Yes.
Lord, the
My
next
lord,
matter.
12:30, yeah?
My lord, item number 15, my lord, I'm
Coming. After 2 p.m. matter, yeah, I am coming.
my lord, I'm praying for time, my lord,
My
for
lord,
extension.
praying for time, your lordship, my lord.
Filing affidavit, my lord.
Who is for 15? You are for between.
My lord, I am for the petitioner, my lord. My lord, pursuant to my lord has directed on the last occasion, 24th June, that the state will file an affidavit within 4 weeks, my lord.
And
Has not been received.
an extension has
But I'm
been
not
paid for on
objecting
behalf
to the
of the
extension,
state to
but
file
my
it.
Matter
cannot be resolved.
Yes, my lord.
Yes, on behalf of the আচ্ছা আপনি দিন তো ইয়েটা
Grateful to your lordship.
Grateful to your lord.
Yes.
এগুলো আগে লিখে রাখবে তো লিখে রাখবে এখানে দাঁড়িয়ে থাকে
Mine is item number 6. Our motion is for the 12:30. But then since 2 p.m. I will take up on this.
Not today.
No, my lord, I'll come back. I'll do the matter.
Okay, who is the other side?
I'm for the respondents, my lord. Respondent number 225, my lord.
So come back.
At 2 p.m., my lord.
No, our 2 p.m. fixed matter. Your learned friend has fixed what I have done.
At 2.
12:30. Now 12:30 matter will be. Yes. Yes, what can be done today?
My lord, in this matter, my lord.
Today course starts from 11:45.
In this matter.
Yes, what? Yes,
Appearing on behalf of the petitioner, my lord. By Mr. Indranil Law, my lord, he is coming, my lord. I have kindly permit me to start the meeting.
That matter?
That matter, my lord. Where, my lord, in spite of having, my lord, eligibility criteria, my lord, being the first MPNL candidate, my lord, he was, my lord, denied from promotion, my lord.
No, it is not that matter. I was thinking that is that disciplinary matter.
Yes, my lord. Disciplinary proceedings was concluded and he was discharged.
After retirement?
No, my lord. It is not after retirement. It is pending, my lord. My lord, chairman himself, my lord, with the consultation with the executive committee, executive committee, my lord, condoned. Thereafter, my lord, this is the event of 2017. Thereafter, in 2022, my lord, petitioner participated in interdepartmental promotion process and stood first. When he was stood first, an inquiry committee has been constituted against him, my lord, saying that the earlier proceeding which has been, my lord, constituted was not, my lord, in accordance with law. My lord, that is not permissible, my lord. Because of the fact, my lord, there is no provision for review under the law. My lord, and most interesting fact is that, my lord, I বলেছি just a fact কত বলেছি পুরো 3 মিনিট বাকি আছে পুরো 3 মিনিট আছে
Let the issue is that my lord, I was আমার পোস্টটা কি ছিল but I was originally appointed as an assistant in the corporation. Subsequently, my lord, I was promoted as senior assistant. And in 2014, I became assistant manager too. Now, my lord, after that, a lady colleague complained against me. Disciplinary proceedings was held. I was found guilty. And my lord, a punishment was imposed on me. Now, my lord, the order of punishment is reduction of pay by 2 stages.
Yes.
Now, my lord, under the staff regulations, I am entitled to prefer an appeal. I preferred an appeal. But in the appeal, it went in my favor, and they said that will be reversed. Now, my lord, the appellate order was communicated to me in 2020. But kindly take page 67. I am not troubling your lordship with the earlier parts. Facts are more or less admitted.
Yes.
The penalty provisions imposed on Sri Devanjan Guha, Assistant Manager, to wide this office order dated 31/3/2018, communicated by memo number such and such, is hereby revoked. Sri Devanjan Guha will get all benefits as if the penalty provisions was not imposed. Fixation of pay shall be worked out accordingly. The order will take effect from 10/7/2020. This
Page
was
57.
Page 67.
67. Oh, sorry.
67.
Yes. The penalty imposed on such and such is hereby revoked. Yes.
And this order is issued with concurrence of the Honorable Chairman and Managing Director.
Yes.
Now, my lord, kindly mark the date. It is 13/7/2020.
Yes.
Now, my lord, the next page kindly turn. This appellate order was implemented on 17/7/2020.
17/7. Page?
Page, my lord, next page, 68.
68. Okay. Yes.
And my pay was prefixed. Now, my lord, thereafter, kindly take the next page, 69. My lord, a promotion notice came. (27/6/22).
Yes.
This is after 2 years from the date when my pay was refixed and the order was passed. After 2 years, a notice came. Kindly see, this corporation is going to fill up 2 posts of assistant manager 1 through promotion from eligible candidates in respect of feeder post assistant manager 2. I applied. Kindly see the next page, page 70.
Yes.
On written test was held on 4th July 2022. And then C. C D. And ultimately, kindly see D. Column D, total marks obtained. First candidate, Devanjan Guho, rank 1.
Yes.
So I was the first empanel candidate for the promotion. Now, thereafter, kindly turns over the page. The board of directors, held a meeting on 22nd July 2022, page 71.
Yes.
In this meeting, kindly see what is the agenda. The agenda is, kindly see page 72. Board meeting agenda is to ratify the decision of revocation of penal measures imposed on Sri Devanjan Guha, Assistant Manager 2 of WBSIDCL. And I am not troubling your lordship with the whole thing.
In the meantime, you retired.
No.
Oh,
He's
you are in
service.
service.
Still in service.
Yes, yes.
Then, last page, kindly see. The board may kindly read last line of that page.
Yes.
I am not reading out the whole agenda. Board may kindly ratify the decision of revocation of penal measures imposed on Sri Devanjan Guho, Assistant Manager 2. So, board meeting agenda is to ratify the decision. Now, kindly see what the board does. Kindly come to page 75.
Yes.
The second agenda, kindly see agenda number 5362. Page 75.
Yes.
To ratify the decision of revocation of penal measures imposed on Sri Devanjan Guha, Assistant Manager 2, WBSIDCL. I'm just reading this, It is important. Initiating the decision, chairman informed the board of directors that since legal retainer of the corporation has opined that there were non-compliances of the legal procedures in revocation of penal provision on Sri Devanjan Guha, Assistant Manager 2, it would not be appropriate for the board of directors to take any decision on the matter. Chairman also opined that one retired judge may be appointed as the appellate authority for hearing the appeal of Sri Guho, Assistant Manager 2. Further, the board, he informed the board of directors that in similar case relating to hearing of appeal of Sri Raja Harijan, Assistant and Appellate Authority was also required to be appointed. After a threadbare decision, it is decided by the board of directors that the legal retainer be and is hereby authorized to appoint a retired judge as the appellate authority for hearing the appeals of Sri Devanjan Guha and Sri Raja Harijan Assistant and to take all necessary actions and arrangements for hearing the above stated appeals by the appellate authority. It was also decided that on receipt of the judgment of the appellate authority, the board of directors will take appropriate decision in the matter in the above appeals. Now, pausing here for a moment, kindly see by this resolution what has been done. But first, what has been done is the appellate order is impliedly set aside. There is an appellate order. That order, board of directors do not have the power to override that order. That is not there in the staff regulations. Nowhere your lordship will find.
Yes.
So board of directors is sitting over the appellate authority as if in a second appeal, and my lord giving a go by to that order. Secondly, my lord, this also amounts to review of the judgment, which has already been passed. There is also no power of review. Within the staff regulations. So either way, my lord, whichever way we look at it, neither they have any appellate powers, nor they have any review powers. More interestingly, my lord, kindly consider 2 years they sat over it. If your lordship sees if your lordships kindly turn back, my lord, your lordship will see all the agendas are of 2022. It is only my agenda which comes from 2020. Kindly see, my lord, starts at page 74. Kindly see the last agenda to note the minutes of the 361st board meeting held on 26th April 2022.
Yes.
Kindly, my lord, on the next.
So it is a malafide exercise of power.
Absolutely.
Yes.
Absolutely. Now, my lord, why? The question is why? What has happened is, the union leader of the corporation, the moment, and it is their document, they have disclosed it. I did not know. It is there in the affidavit in opposition. But at the moment the notice of promotion came and I applied for promotion, well, he sent a letter to the corporation saying that this appellate order is bad. Now this, well, your lordship will find in the affidavit in opposition.
Leader became competitors of the petitioner.
What?
Leader became competitors of the petitioner.
Yes.
For that promotional post.
No. Oh. He is competing for a different post.
Yes.
Not for my post. But what he has done, he has taken the complainant under his wing. And he serves a legal notice where the lawyer says that the union leader is my client and the complainant is my client. And after 2 years, he says that that order is bad and it should not be implemented. And it is on that basis, this agenda is done, this resolution is done, and what the chairman says, well, I will show your lordship, it is shocking. Well, the chairman, he says this other, I will demonstrate from the documents, this leader of the union, he does not participate. He has applied for promotion in a different post. He protests and says that no, if the petitioner is allowed, I will not participate. He did not participate in the proceedings. He did not sit for the exam. He did not appear for interview. And the chairman says that in public interest, he should be promoted. But what is happening in this corporation, your lordship will.
Have you made him a party union leader?
I think that is a part of this prayer of the
Yes. I will show it.
No, not prayer. If there is a challenge that let us not go beyond the writ petition.
I will not go beyond the. What am I? I am challenging, my lord.
Then let us confine.
Confine
it to the challenge.
I am challenging the action.
No, yes. No union leader, not party to this process.
No.
Neither the complainant.
No.
Neither the complainant is a party.
No.
So how I can hear?
Because why I tell you, lordship, I am only demonstrating how the malafide has come. I do not want any relief against them. I have not prayed for any relief against anybody else. I am only demonstrating the malafide from the documents which he has annexed, not my documents. From the opposition, I will show. Malad, his own director, after this is Malad basically an afterthought.
Okay, so I got your. So I think.
Malad, 2, 3.
I think the answer of the queries, 2 queries will conclude the hearing.
Yes, Malad, the 2.
So you just show after 2 years, after giving effect to the order of the appellate authority, how and how. Under which provision, which rule, you can revive the proceedings. You just so revive the proceedings and see till revision, appeal of the appellate authority.
That is one query for me, Lord. What is the other? Lord, she was just for, and there are 2 queries.
Yes.
This is one. The other.
Lordship.
Okay, you give that
I will,
question.
but before that, my lord, lordship will fix it because I have arguments to make on the point. I'll just demonstrate my arguments to your lordship, then I'll evaluate it on the next day. Number one. One second. Yes.
পরের দিনই বল না
পরের দিন বলো indicate করে দেবো না পয়েন্টটা আচ্ছা he wants me to argue.
Because, my lord, why I tell your lordship, my lord, two other documents I would want to show, my lord, on the next day, whichever day your lordship fix, my lord, two documents I will show. Thereafter, let him make his argument. He has understood what is my argument.
Argument could have concluded.
No, lord, I will need at least 45 minutes to an hour.
45 minutes.
Yes. Before I lose my lordship place.
My lord, he has got a
because lordship will
55 minutes.
Yes.
In the bench which has only 100 matters. In the bench which has 700 matters,
because of
the
fact,
time would be shortage.
No, I cannot. I tell you lordship why.
You include the list.
No.
If you include 2000 matter, I will give 5 minutes.
Yes, possibly I have come.
Thereafter, I shall not.
Last day.
After 5 minutes, stop.
But possibly he has argued for not 3 days. Let me have the.
If one bench is forced.
I can't help it because lordship has to consider before I answer to your lordship's query, subject to correction, lordship has to consider whether an action which is nullity in the eye of law, whether it can be raised at
Void ab initio.
nullity, void ab initio,
Yes.
whether it can be, whether
Yes,
time
tell what is your
time
stand.
span,
Void ab initio.
whether time span can come into the picture at all.
This wrong can be rectified at any point of
Number
time.
one. Number two, his second point was whether I can revise it.
Whether board of director can sit in appeal over the
It is
appellate.
void ab initio where the question comes of sitting in appeal at all. It is void ab initio, it is null and void. The question does not stand in the eye of law. Where is the question of coming up sitting in appeal if there is nothing in the law? But I have to cite decisions to that, your lordship.
So, side.
But I will take time. I have to place these documents. I cannot do it at 125.
My lord, kindly see. Authority does an act, and the same
Let
authority
him then conclude, then I'll read.
and the same authority comes and says that my act is void.
I can do that under the general clauses.
You just shorten the issue. A point of law. One disciplinary proceedings was initiated against an employee. He suffered some punishment. Thereafter, he preferred the appeal. Appellate authority set aside the order of punishment and revoked the order, imposing the punishment upon him. And his punishment was reduction of pay, as I have understood from you.
Absolutely.
Reduction of pay. His pay was refixed, and he was enjoying that pay
for two
revised pay.
Correct.
For 2 years. Suddenly, board of director in one meeting included an agenda for ratifying the decision taken by the appellate authority. Then the board of director noted that the decision of the appellate authority was wrong and need to be set aside.
No, I'm sorry. That is why I have to argue with the
Yes,
documents and everything. The decision of the appellate authority will be considered by lordship to be wrong or right only when the appellate authority who has decided has the jurisdiction under the rules to decide it.
Okay, so appellate authority has no jurisdiction to sit in appeal over the order imposing the punishment. The board of directors says. Yes. Thereafter, whether his pay was again refixed.
Nothing.
You have
the promotional.
No, it is only at that stage, my lord.
So whether you have allow him to enjoy the pay scale attached to the promotional post.
Yes. No. Not promotional, but as per the order of the appellate authority, whatever the appellate directed, it was revoked. So he was getting the original pay, still getting.
He was
promotion
getting the original pay scale. Now he has returned.
No. Still in service. My promotion, my lord, is protected. I will place it on the next day. The first interim order when I move this petition, it is no. I am not getting it. It is protected that if I am successful, my promotion will revert back to that day. That is there.
So your claim is that board of director cannot sit in appeal, even the decision of the appellate authority, which has the decision has already given effect to, and acting upon such decision, they have revised your pay. It cannot be done. His plea is that order is void ab initio, since the appellate authority has no jurisdiction
that is one
to entertain
that is one. Number two.
So you satisfy this point and some judgment will come.
Number two.
Hearing concluded.
I have other points. That is one point. There are other points.
Yes,
kindly give it a 2 any day.
Again, I shall forget.
No, lordship. The moment he started, his lordship remembered.
No.
Again, forget we will.
Yes, my lord, if it is 2 p.m., my lord, we can conclude it.
It kindly keeps it on next
Huh?
Wednesday, 2 p.m. We'll conclude.
In the meantime, you also do two or three matter. Eh, and I forget which matter you are going. After 2 p.m. দেখুন না 2 p.m.
Wednesday করে দিন না, তিনটে। কোনো অসুবিধা আছে?
Had the learned advocate appealing for the your first 2 p.m. matter? Conclude.
Yes, yes, my lord, we want to finish.
Huh? Huh? Tomorrow, okay, tomorrow. 18টা তাহলে tomorrow করে দেবেন উনি okay. Tomorrow 12:30. Your matter is a hard scale of pay of 3%. Pension, it is different matter. Oh, that matter. Yes, yes.
না
Okay.
submit report with regard to the unauthorized construction on the Dari Road. Lordship, in compliance
Item
to
number
order
125.
June 2025, Lordship, the concerned engineer went to the spot and seen that all have been removed by the shop owner.
I want
to this in any.
I expected after signing the order that it would be.
We are observing outside the court. That is why.
Not really, Lordship, not really. That is his part of the story. My part of the story is different.
Because given answers. So you are given say redress.
Lordship, I have one humble submission to make. Previously, my client had filed 107 CRPC, and that was effective for 60 days. And at that point of time, they had removed and dismantled the shed. Again, after the expiry of 60 days, they came up. So it can be well assumed that now they have removed all these things. But there is no assurance that once this writ petition is disposed of, after 3 months, they will again come up. There is no assurance. And how many times can I expect that my client will be coming up by way of writ petition before this Honorable High Court? This had happened. There is pleading in my writ petition like that.
Photographs has been annexed there.
Yes. Basically, why I am saying this thing, now if you run any administrative post anywhere in that district, in a state, now you will not find any place in a city, forget about in a city, even in a Mufasal town, to set up an office or government office to serve the public. Every day new schemes are being introduced. New act is being promulgated. But for that reason, if municipality tomorrow needs an additional room, municipality will not be able to make arrangement of that place, that where the room will be.
Great. Lordship observation is 100% correct, Lordship.
No, in this way, it is applicable to the judiciary. It is applicable to all office. You will not find any place where one office would be constructed.
Yes, Lordship observation.
Of the office, the people will get some beneficial.
Yes, Lordship. For this catering service,
from such scheme,
public service, there will be no
yes.
place. Lordship observation is.
Find any space to build one additional courtroom.
Lots.
Yes. And here there's some what I said, some political leaders are there, some
Yes,
there.
yes,
They
that is the issue.
taking money.
Yes, that is
you
the issue.
sit, I shall see.
That is the issue, Lordship.
But today you construct one office room. Tomorrow you will find that office room surrounding all place. There are some ghumti light,
yes.
Some temporary structure. Some people will come. Tomorrow they will claim their right. Today temporary structure, tomorrow permanent structure. Thereafter they will claim right. Adverse possession over the government land.
Several operation was there.
They will not be able to remove them.
There are so many markets like Gori,
yes.
everything.
Yes.
They are removing hawkers again and again. That is
same problem. Indiscriminate allotment of the government land by some, what I say.
That cannot be allotted. That is the road.
No.
Under any circumstances, that cannot
in
be
that
allotted.
circumstances, you consider that it is your personal problem and it is the problem of the society. In case of conflict, I shall consider the interest of the society.
Lordship.
So no order in this fashion can be passed that in future they will, if such problem arise again, then you are to come again.
Lordship, this doesn't give a permanent solution. Again, they will come. I have pleaded in page 5, Lordship. Because, Lordship,
no, the municipality will not allow.
should take the
No,
responsibility,
will not
Lordship.
allow. But
They should take the responsibility.
Okay.
And one more indulgence, Lordship, I have made a prayer. I
Appearing for the BSF led by Mr. Kollan Chakraborty.
BSF.
I'm appearing for the petition led by Mr. Ujjwal Rai.
Yes.
Well, there was a direction for exchange of affidavits, my lord. The affidavit in reply is ready, but I am under instructions to submit that we weren't able to serve it upon the learned advocate of the BSF. So let's serve it into the yes.
So can I take up?
Today we are receiving this reply, ma'am. Then kindly fix the date.
If you want 2 p.m., then it will go 19th August.
19th August.
2 p.m. If you want
Fine.
to get it fixed at any particular time, it would be on 19th August at 2 p.m. So I am fixing on 19th August at 2 p.m.
Fine.
Or 19th August second 2 p.m. তাহলে দেখুন একটা যদি নেই ফার্স্ট 2 p.m. হবে 20th August. Huh? So you give the affidavit in reply.
Sorry. Pardon.
Acha, affidavit in reply filed by Mr. Chakraborty, learned advocate, appearing on behalf of the petitioner. Acha. ষোলোটা 18টা তো টাইম নিয়ে চলে গেছে 18টা তো টাইম নিয়ে কবে 12:30 নিয়ে বেরিয়ে চলে গেল হ্যাঁ তো আমার সেকেন্ড হাফে অন্য কোথাও মামলা আছে আচ্ছা এমনি ডাক হয়েছে 15 পর্যন্ত তাহলে 16 থেকে
126 I am for the respondent, madam.
156
126 2 p.m. matter, madam.
126 appeared. Your junior came.
Oh yes, madam.
তাহলে আপনি করে দিন ওই যা পোশাকের নাম দিয়েছি তো ওটা আপনি কল্যাণ চক্রবর্তী আপনি থ্রু বিসি করে দেবেন কল্যাণ চক্রবর্তী থ্রু বিসি হ্যাঁ ইয়েস আর পোশাকের নাম তো এমনিই দেবেন হ্যাঁ ঠিক আছে নেক্সট
I am at circuit bench, ma'am.
Yes. Your junior says just today, we have received the affidavit in reply, so
Yes.
fixed it on another day.
Yes.
Accordingly, date has been fixed on 20th August.
Yes.
Okay, conclude hearing on that date. Yes. Item number 16.
Chief, I am for the petitioner in this matter. I am for the respondent number 226.
Yes, do it.
There was a direction for filing a report, my lord, from our side.
Yes.
This is the copy of the report.
Have you given the copy? Yes.
Lordship, we intend to file a supplementary affidavit in this matter. The advance copy of the supplementary affidavit has already been served upon a learned friend appearing for the company and also the EPFO, Employees Provident Fund Organization. Lordship gives the leave, but then I can hand up.
Okay, supplementary affidavit file on behalf of the.
I can start, my lord, on the matter.
Why is supplementary affidavit? Give it to the court. You saying that I want to file it and keeping it with you. Yes. Supplementary affidavit filed on behalf of the petitioner is taken on record. I have been informed that a copy of such affidavit had already been served. Was served upon the learned advocate entering appearance on behalf of the respondents upon the learned advocates করবেন আচ্ছা the report as produced as filed on behalf of respondent number 226 is kept with the record. Yes, what's the dispute? What
Another
is the
report was filed.
another report?
Another report was filed by the EPFO. My learned friend is appearing for the company. Now, my lord, I have taken exception to that, my lord. May I file that?
Oh,
Jointly, my lord. All these things have been done, my lord, while we are sitting all this time. The copies are also served upon my learned friend and the other copy has.
Another report is not with the record.
Anyway, my lord,
I have only one report. Another report from EPF authority.
Should be there, my lord. That was
EPF authority. Who is appearing for EPF authority? Huh? You are for Union of India. EPF authority, another advocate.
Yes. That report has a copy of that report has been served upon.
Respondent number 10 didn't appear on earlier dates. 9 appeared. Mr.
9 and 10.
Tiwari, Mr. Tiwari appeared.
Yes, Tiwari, lord.
Huh?
Yes, Tiwari. One previous
Order says he represented respondent number 9. Respondent number 9. Respondent number Regional Provident Fund Commissioner. Respondent number 9 and 10 would be Kolkata and Kerala.
Died in Calcutta, working in Kerala, and all the retirement and benefit that was dictated by the order of the Kerala Ministry of Provident.
My lord,
Number 10 is the answer.
well, subject to one little correction, my lord, the employee was employed in Kolkata office, but her registration was from Kerala. Yes, and the headquarter is also in Kerala. That's why, my lord,
Petitioner all along was employed in Kolkata.
in Kolkata, yes. Yes, her registration was from Kerala.
That is the. My lord, may I?
So you served, have you served?
I served.
Respondent number 10.
Yes, sir, the report on me, lordship. Against that, I have taken the composite.
Respondent number 9.
9 and 10 are the same thing. 10 is actually, my lord, for 9.
Now, my lord,
One thing, since আপনি আরেকবার লিখুন তো আরেকটা লিখুন and the exception filed by the petitioner. আচ্ছা.
By 9 actually.
In respect of the report, a comprehensive exception filed on এবার আপগ্রেডের ম্যাটার ধরুন, দেখবেন কেউ নেই। হয়তো
Item
বোধ-
number 19.
19 দেখুন কেউ নেই, কিন্তু নামিয়ে দেবেন এগুলো, বুঝতে পেরেছেন? আপনি দেখে যান, যেগুলো হবে সেগুলো হিয়ারিং এ ঢুকিয়ে দেবেন, এগুলো আপগ্রেডেড থাকবে না।
Item number 20,
হ্যাঁ, বটম
21,
Sir, I'm for respondent number 3 and 4.
হ্যাঁ, ওকে, প্লেস অ্যাট দ্য বটম,
22,
বটম, ডাকুন ডাকুন ডাকুন, যত পারেন ডেকে দিন। 22 for the petitioner.
Yes, Lordship.
Who is your other side?
Occasion Lordship on 6th, kindly come to the order dated 6th February 2025.
What's the matter about?
Yes, Lordship. Here
Ah.
the possession of the land was and laid by Mr. Khan, Lordship.
So land acquisition matter.
Yes, Lordship.
Huh?
Yes, Lordship. And
Mr.
Lordship, in this
De.
matter, oh, Lordship,
Mr. Chondi Charan De.
they and Shomit
De.
Bandyopadhyay. I'll kindly, Lordship, kindly come to the last order, 6th February 2025, Lordship. Liberty is given to the state to file a fresh report in form of affidavit in terms of the order dated 24 January 2025. Lordship, till date.
So, madam, unless this report is filed, the writ petition cannot be taken up for hearing. Because one coordinate bench concluded that report is required.
Earlier occasion,
Report to you,
Yes.
but not to the court, most probably.
No, court they have filed.
Court they have filed.
What happened if I am not?
No, এটা affidavit in service.
Karan, kindly turn to the order itself. Peruse the report. Peruse the report.
Yes, report.
No, peruse the.
Yes, court,
Filed by
uh,
the respondent.
yes, one report was filed,
Yes.
but most probably court was not satisfied with the report
Yes.
or any further clarification
And fifth,
necessity of further clarification was felt, and hence a fresh report. Liberty is given to the state to file a fresh report in the form of affidavit in terms of the order dated 24th January 2025.
Lord, I tell you, Lordship, what happened. Now, my Lord, barring the merit of the matter, they offered for direct purchase in terms of policy. My contention was this, that there cannot be any blanket offer. There should be time-bound rather purchase. No, my Lord, they said that as per the same memorandum, fund will be allotted to the Jela Parishad by the administrative department for payment of the landowner. Hence, the completion of entire procedure largely depend on the placement on the fund. But I cannot be, my Lord, held for a
Mr. Bandyopadhyay has come.
Yes. So therefore, my Lord, if this is the situation, if that be the proposal, but I am not agreeable to this proposal.
You take this side, Mr. Bandyopadhyay. Take.
There is within him, Lord. This matter, but brief is with him. I'm just, Millard, I'm calling.
But one report is required to file. You are required to file a fresh report.
The brief is lying with Mr. J.'s chamber, my Lord. I requested him to appear. He is coming, my Lord. I just, my Lord, inform him. Sorry.
Oh. State is saying a numbers of petitions for direct purchase. Regarding direct purchase,
That is not the law.
are pending.
My Lord, a policy cannot even there is 1,000 of this type of order. Even then, a single order is not binding upon the other matter, because this is an offer. This is up to me whether I will accept it or not. Policy cannot override the statute. The statute, the policy has not incorporated in the statute. Moreover, policy in respect of where land has not been taken over for the purpose of acquiring a fresh land. Here the possession has been taken over. In a lapse proceedings, 9(3)(b) has been issued, which is also been lapsed. So there is no other alternative but to initiate a fresh proceeding for the purpose of determining and payment of compensation.
Under 13 Act.
Under 2013 Act. Moreover,
So I am making it not today. What can be done? Let Mr.
Then my lord, not today and tomorrow.
Not today and tomorrow. Now on the date, again, upgraded matter will be placed at the top.
Kindly fix up a date at the top.
They are not coming. আচ্ছা আপনি ইয়ে করে দিন ইয়ে আবার হাট বললে তো সময় কেন ঢুকিয়ে দিন হ্যাঁ এদিকে হাট the learned advocate appearing for the respective parties. One week hence, file report in the meantime.
28th February.
Report. I have been told the report has been served upon them.
No, fresh report has ready. No, fresh report has been served. This is the first report.
No, fresh report.
Fresh report has not been served.
So whether another week should be given.
Kindly see, 20th February, the matter was due to appear. And today in the 2nd of the July. Kindly see.
Oh, it is of 2016 matter. You take instruction. You take instruction. He is not.
This matter, my lord, report is ready. Do not contact him, my lord, after this.
Okay, 1 week hence.
And the next matter, same order may be passed. The arising of the same order.
Oh, next matter, same order. Yes. Mr. Day has come.
Wait করতে হবে
Have you prepared the fresh report?
Yes.
Okay. কেটে দিন order দেখি কি আছে দেখি
ডিরেক্ট পারচেজ করে নেব তোমার কোনো চিন্তা নেই
Your learned friend is not agreed to accept your proposal.
No, that is not my proposal. Sorry. No. My lord, that is not my proposal. Please. This is not my proposal. Yes, kindly have a look at the report.
এই যেটা দিয়েছিলেন সেটা দিলেন না পরেরটা দিলেন সেইটাই দিবেন No, actually, the matter has not been settled amicably in between. Acha, fresh report. Press report submitted on behalf of the petitioner.
22 শরৎ তো শরৎ কি 22 দেখে নাও 22
My lord, we have filed the press report.
Oh, the press report filed on behalf of the state.
Here and now my lord, accept it or may not accept it, because I tell your lordship, why the earlier report was not accepted by the court, because of there was no specific affirmation as to when they are going to complete the process. Let me see. But unheard of. This sort of side comment is unheard of.
See my report, page 3 and 4, my lord. এখন কেন ঝগড়া করো?
আর আমি ঝগড়া কেন করতে যাই? কার সঙ্গে ঝগড়া করবো? আমার কি দরকার আছে? আমি মামলা করতে এসেছি।
You come to page 12 and 13. Mr. Pan.
My lord. আগে দে। This is the, my lord, inter-department communication. This is the inter-department communication.
How about they now,
my lord, kindly see.
now they have,
Now, kindly see, my lord. Kindly see.
now they have produced it before the court.
Yes.
That is,
Now,
it is
if
now a
your-
public document.
If your lordship direct them to complete the entire process within 3 months, I am agreeable. Kindly direct them to complete the entire process within 3 months. Because I cannot be said, when the fund will be placed, then this will be done. This is not done. Kindly make a time bound.
Your lordship will see my report,
Yes.
page 4. Paragraph 2. District Land Purchase Committee would be requested to approve the proposal for direct purchase of land and send the estimated value of land as per valuation of ADSR, and to send the proposal to the administrative department within the next 1 month. Within 1 month, that will be done. My learned friend knows how the purchase procedure is complete. After that, next paragraph. The requiring body would be requested to get the fund released within 3 months from the District Land Purchase Committee. They will pay the money within 3 months. And my lord, to give the money to the procedural and take the purchase committee will get the, my lord, the land is registered. That is for 1 month. That is 1 month, 3 months and 1 month, 5 months. My lord, your lordship can assure that that is the special land acquisition officer, the press report. That report was, my lord, was pleased to ask us to file that report. And we have filed this report. My learned friend, my lord, my learned friend said, my lord, within 3 months. But our specific, my lord, abatement is 1 month, 3 months and 1 month. That is 5 months.
My lord, I am very poor in English, I admit.
No.
My lord, kindly see, my lord, the language. Kindly see the language. He said this is time bound. Kindly see. District Land Purchase Committee would be requested to approve within this period.
My lord,
Exactly, that's why I am
my lord,
requesting
now,
your
my lord,
lordship.
my lord, your lordship now
direct
pass the order to that effect that District Purchase Committee will complete their procedure within 1 month and ask the money for the requiring body, and requiring body will pay the money within 3 months from that date. And after that, my lord, when the money was we receive the money, we must pay the amount to the petitioner next
That's why I
within
have
1
said,
month.
my lord,
My lord, that is that order.
The entire process within 3 months.
I said that
Suffice
is
the
the 5
purpose.
months.
Your lordship is not supposed to direct the purchase committee to in this way and place the fund this way.
No, before that, court is to ascertain whether you are agree to their proposal that you will.
For direct purchase, I am agreeable. My
Agreeable.
instruction is agreeable.
Yes.
Provided this has been done within a stipulated period.
Yes. Stop.
Yes.
Okay. Now you assist when the land was acquired. If your lordship kindly turn to the list of dates of mine in the writ petition. List of dates, yes. Everything is clear. Possession of the land was taken over on 22nd of January 1972 by issuing an order under section 3(1) of the Act 2 of 1948. Then, my lord, the property was acquired. How many lands? How many plots of lands? There are, my lord, altogether, my lord. You are owner of all these plots of land? Yes. Huh? There is no dispute. Oh. There is no dispute. আচ্ছা, stop. আসুন তো। May I take your lordship's leave? Yes. The pageant petition has been preferred. Nothing can be done. You have missed the bus. What can be done?
With lot of effort, Lord, we have been in a position to apprise your lordship. Your lordship was.
Yes, I have given a lot of time.
It is not the client's problem. It was my difficulty. I was, my lord, held and I was making submissions.
Give opportunity to all.
But I apologize.
Okay,
That's
your matter will not be dismissed, but it will be placed under the heading.
Lord, I am ready
hearing.
to argue the matter, my lord.
No.
I was, my lord, not. I was. my lord,
In that
not-
circumstances,
submissions.
it would not be possible to run the court effectively.
Lord, I was,
Okay.
my lord, not.
Okay. No.
But I
Rule
apologize.
is to be uniformly followed.
My lord, I apologize, my lord. It is not that I am avoiding.
Don't
I-
make this apology.
My lord, I leave it to your lordship, my lord. My lord, I was in difficulty, my lord. I was making submission before another court, my lord. That is the truth.
What can be done? No.
My
Who is
lord,
your other side? So he is also not there.
21, my lord, they are not appearing. The bank is not appearing. That is the grievance. We are waiting for 9 years for refund of money, land not given to us.
Have you made any simple
Yes,
any application for early hearing or anything like that?
My lord, we had mentioned the lordship was, and early hearing application is CAN 3.
The matter was filed in the
2016.
year 2016. 9 years you have
We
waited.
are waiting for this 9 years.
This court has fixed this one, not only one day.
Lord, one
After calling some matters from the top, every day again the upgraded matter is placed. Okay, আপনি এটা upgraded matter-ই নিচে ফেলে দেবেন। Hearing নয়, upgraded matter-এর bottom-এ। At least it can be done.
I have learned the lesson. I have learned.
No, it should not. Everyone should be given opportunity.
It's my mistake, my lord.
Everyone should be given. Tomorrow, I think upgraded matter will not be placed. Another matter, there is a part-hard matter, returnable matter. I am to make an report so that everyone can get opportunity to place their case.
And
now, one person again will go on taking time. Again he will come. That means you have not so much urgency. So allow the person having urgent matter to move. Next.
I apologize once again.
Next,
But I'm grateful.
no apology.
I'm grateful.
Apology is not accepted here. এখানে একটা বোর্ড দিয়ে দেবেন। ঠিক আছে? হ্যাঁ।
People of Christ.
Debit card is not accepted here. Credit card is not. Apology is not accepted here.
But we are always
Okay.
apologetic for our mistakes.
Item number 24.
Lordship, in this matter, Mr. Joyanto Kumar Mitra is appearing on behalf of the university, my lord. There is some difficulty, he has not come to court today. I'm praying for some accommodation, a long accommodation may be given, my lord.
My lord, I appear for the petitioner, matter of 2018. The petitioner is not getting his arrear dues for a very long time.
Retirement dues.
Arrear dues. He's still the head of the department, Kolani University of the History Department, my lord. He was appointed as the lecturer. Status was confirmed by this honorable court, went up to Supreme Court and affirmed. But his arrear dues are not being released for
It
reason.
should be given retrospectively also.
But they're not releasing the dues, my lord, for several reasons. I'm ready with the matter, my lord.
Okay, not today.
Kindly fixes up sometime in the mid of August.
Huh?
In the mid of August, my lord. Kindly
It can be fixed next
August.
My lord.
next week if it may be taken up
Yes.
any day, my lord.
Going to lead us, my lord, in this matter.
I'm led by Mr. Shoptan.
And you have the learned advocate appearing for the respective party. Release the matter for further consideration on
Deeply.
My lord, any time prior there to 21st, because he's been suffering for a long time.
he is saying that it's placed in the month of August. What
I
can be
did
done?
not pray for.
What court will do, you say?
My lord, if your lordship takes up the last order, they have played for a long time.
Why you are seeking so long date? Why you are seeking so long date?
Because, my lord, Joyanto Kumar
He is ventilating that his deprivation. Oh, you are here. Okay.
Last time you see the last order, long accommodation was sought for by the petitioner.
Huh?
Long accommodation was sought for by the petitioner on last occasion.
So-
Today, my lord, we are not in this way, my lord. My lord, he will address, my lord. He has some difficulty, my lord. I was asked
Kindly
by
takes
his
it up
staff-
next week, lordship. I am prepared. I can move the matter. I am not seeking anytime before that. Because
So you are
2018 matter.
trying to delay the matter.
Yes.
Not at all.
Huh? It is appearing you are seeking long date.
No, my lord. He is not happy.
Actually, allegation is directed against you.
No, my lord. He is leading.
Every writ petition, allegation is directed against respondent. That respondent has not done it, or has done it, which forced me to come here, direction. So if you to go on taking a long time, okay, আচ্ছা একটা কোনো ফাঁকা ডেট ফাঁকা হবে ওই তার আগে দেখুন তো ওই 11-12-4 মধ্যে একটা ফাঁকা হবে হ্যাঁ আপনার 15 before Independence Day you will not do it.
But we shall start and then they can give their rejoinder thereafter, subject to convenience of my lord.
How may he is in difficulty up to 15.
Then lordship will kindly fix
Thereafter
a
he will
time.
accept your pair, don't worry.
My lord will kindly fix a time then, lordship. A time may be fixed, the matter may be heard out.
So 18th at 2 p.m.
18. I'm deeply
18th at 2
obliged.
p.m. Second 2 p.m. matter.
2 p.m. matter. My lord,
Second 2 p.m. matter.
my lord, the affidavit in
Hey,
reply may be taken on record. This is a change brief, my lord.
Order is required to be passed. No, order is required to be passed.
My lord, the affidavit in reply may be taken on
Filed on
record.
behalf of the petitioner is taken on record. Heard the learned advocate appearing for the respective party leaves the there is one 2 p.m. matter on that day.
Deeply
Okay,
obliged.
second your matter, second 2 p.m. matter.
Deeply
Yes. Next. দেখে যান তো। না থাকলে তলায়
Your
পাঠিয়ে দিও।
lordship kindly see the last direction. By which the lordship don't.
I'm for respondent number 5 and 6.
To file affidavit to complete the affidavit.
My lord,
Where is your fee?
my lord, we were supposed to file the affidavit in reply to the demurrer application and affidavit in opposition to the writ petition. My lord.
Nothing has been done, Lord.
But my lord, we seek 1 week's time, my lord, because since the authorized signatory is traveling, my lord. 1 week's accommodation may be given, my lord.
An application for dismissal of the writ petition. In that application, affidavit selection were there. But the petitioner has filed opposition. They have not filed our reply. So far as the petition is concerned, I have filed my opposition. I have served upon them. I have filed as in I have served my opposition upon them. They have to file the reply to that. If they have not received it.
Lord, your lordship, we have done everything, Lord. Your lordship kindly see the last order. And by his lordship don't.
Affidavit in opposition on behalf of the petitioner. Can 1 or can 2?
Lord, demurrer.
Who filed can 1 and can 2?
Can 1 filed by the 30/1.
My lord, I appear for the respondent number 5 and 6. Can 1 has been filed.
You say can 1 filed by respondent number?
Respondent number 6.
I have not seen the cost title. Respondent number 6.
6.
And can 2
by respondent number 4.
By respondent number 4.
Part 1 development of the.
Respondent number 4.
Can it?
Whoever maybe who can I go?
Petition, I am disciplinary copy. Other respondents are not concerned.
Oh, okay, I'm coming.
I will like to complete it. Between me and the petition.
So you have to serve it upon the state also.
Yes.
At the application, he is a party to this proceeding. So he has a right to get to receive the application filed by any of you, any of the parties. So serve. He may also file affidavit in opposition or his response there too.
Application of a respondent can another respondent.
Acha, 2 separate affidavits in opposition filed by the petitioner in respect of 2 application.
Can 1 and can 2.
Colon or nale hyphen din. The application being can 1 and can 2 filed by the respondent number 6 and respondent number 4, comma respectively, comma is taken on record. ঠিক আছে? আচ্ছা, affidavit in reply filed on behalf of respondent number 4 to the Affidavit in opposition filed by the writ petition in respect of the application being can 2 are also kept on the record, is also kept on the record.
I have served upon
আচ্ছা, affidavit service as একদম উপরে as produced on behalf of respondent number 4 is taken on record. Have you served upon the state? তাহলে এই affidavit service কেটে দিন, you serve and then file fresh affidavit service. আচ্ছা মিস্টার আচ্ছা মিস্টার বন্দ্যোপাধ্যায় learned advocate representing the state submits that no copy of the applications or application দুটো আচ্ছা
nothing.
আচ্ছা application no copies of
Any of them.
of the application has been served upon the state. Stop. In view of the above, the respondent number 4 and 6 are directed to serve the copy of the application presented by them. ঠিক আছে, to Mr. Bandyopadhyay, learned advocate appearing for the state. Stop. Acha, the parties are directed to exchange their affidavit in respect of the writ petition as well as in respect of those two applications before the returnable date. Stop. List the matter for further consideration. How much time you will take?
We have completed everything.
Huh?
Lord, so far, Lord, respond number 6, he has not filed the affidavit in.
My lord, my lord, my affidavits are ready.
3 weeks?
Yes, sir.
Yes, my lord, 3 weeks.
3 weeks stay.
Mandatory, otherwise.
That will depend when you will serve. আচ্ছা আচ্ছা in course of tomorrow করবেন ওই যে স্টেট কে হ্যাঁ
My lord, we shall serve, my lord, we shall serve.
আচ্ছা list the matter for further consideration 4 weeks since you complete parties are at liberty parties are at liberty to exchange their affidavit in the meeting. এরকম ভাবেও লিখতে পারেন যে লিস্ট দ্য ম্যাটার ফর ফার্দার কনসিডারেশন 4 উইকস হেন্স, তারপর তলায় লিখে দিলেন পার্টিস আর লিবার্টি টু এক্সচেঞ্জ দেয়ার এফিডেভিট ইন দ্য মিন টাইম অ্যাজ ওয়েল অ্যাজ টু দ্য অ্যাথর। ইয়েস নেক্সট।
I am grateful, my lord.
ইয়েস হরর করে লিখেছেন 26 What's the problem?
Lord, petitioner challenges an order passed by the authority, my lord, refusing.
Before my
to,
learned friend start, my lord, may I just point out one thing, my lord. There was a direction, admittedly, for filing of opposition, my lord, but we have not, we could not file it, my lord. But I will be seeking, my lord, a sort of time extension of time, my lord, for filing this, my lord. I am a newcomer in this brief, and so, my lord, if your lordship so please, my lord.
Lord, only one thing, my lord, the direction.
When you will file?
2 weeks.
My lord, only thing, my lord, kindly considers in 2021, my lord, the direction for opposition was given. My lord, that after there several dates have passed.
Preemptorily, I am now started using the word
preemptory. In default, my lord, no liberty further.
Preemptorily means I don't ask
any,
include any default clause. That means
let there be a default clause of hearing. Well, I'm saying default clause of hearing.
Preemptory perhaps includes that, my lord.
No, my lord, kindly clarifies that. If it is
so since default clause has not been included, it would not be treated as a preemptory or mandatory direction.
My lord knows our, my lord, soft corners, my lord. My lord, kindly.
Interpretation of statute. আপনি লিখে দিন তো আচ্ছা ইয়ে Mr. Samanto, learned advocate appealing for the state, prays for extension
Honorable High Court in Division Bench has clarified the position. Thereafter, they are refusing license. And all the time their one plea is that state government is yet to bring a policy. Well, as of date, since 2018, there is no policy. But only difference is there would be a policy. There would be a bylaw. But as of date, there is no bylaw. Now, my lord, time cannot be granted to the state to frame a bylaw
On that
and my lord,
date,
defeat the claim
on
of the
one
petitioner.
date, what I said, I could not but express certain annoyance, most probably DBC matter. 7 years, 9 years, they have not filed affidavit. Actually, the matter is pending for the reason that the respondent did not file affidavit. I take in information how many matters only either by the state, Union of India, DBC and such authority, they will not file affidavit 2 weeks. It would be more than 2 years,
Absolutely.
10 years.
Absolutely.
They will not care to file affidavit.
Absolutely. And my lord, I tell you, Lordship, this affidavit was called for on the submission that state is on the verge of
Yes.
policy, so that it can be brought on record.
Sometimes a pleadings and the document is required, disclosing their stand of the state.
And my lord, similar issue, my lord, fact.
Actually, petitioner is a common man. He will annex what the documents which is available to him, which are available to him. Now the department will come. Look, it is our policy, it is our order, it is such and such. Then the effective adjudication of the writ petition will be done.
But in 2024, in this, my lord, in this matters arise out of Hackney carriage. My lord, my learned friend knows he is appearing there. My lord, in 2024 also, same plea has been taken before the Honorable Learned Chief Justice's bench, where they say government will form a policy. So from 2018 till 2024, there is no policy. Where in 2025, there is no policy.
Say, without knowing the reason.
Well, I know because I am there.
No.
There is a report to that extent.
There
There is a report to that extent. Let him deny.
Yes, I am denying.
Okay, Mr. Samanto, so don't ask, generalize Mr. Samanto, particularly in this case, you file within 2 weeks. Okay. Give honor at least to my order.
Yes.
Yes. Yes. Next.
27.
My lord, the very short matter. Corporation, my lord, already certified the construction. There was no sanction plan. If your lordship kindly come to page 23.
Okay, let me see the prayer what you want. To make an inquiry investigation to the complaint of the petitioner dated such and such and to take steps according with law. Veracity of the complaint. To take steps to demolition of unauthorized additional construction made beyond G+1 construction such and such carried on by the respondent number 8. Have you given notice to respondent number 8?
My lord, initially in the motion stage, my lord, despite notice, he did not appear. Matter is appearing before lordship. Again, my lord, he was notified, my lord, it was served on him.
Okay. So I am asking them, you consider,
Yes,
let
now
them consider.
page 23 once. Page 23.
No, now don't ask the judiciary to apply its mind.
No, my lord.
You have approached them.
I
have approached them. Let them consider first.
Yes, my lord. In view, my lord, in the light of my lord, already communication has been made, my lord, that 21st March 2020. Page 23.
23 years. Information under in connection.
In reference to the above mentioned application.
No sanction plan issued against the above holding
for construction of the second floor of the Hornbill.
Achha. So there are no sanction plan for the second floor.
Yes.
Now the respondent number constructed second floor without any sanction plan.
More than my lord, my instruction, my lord, not only second floor. Be given, my lord, to the private respondent also, my lord, for a hearing and dispose of, my lord, the proceeding.
Yes, I mean, Asunto. What's your deal?
177(1) proceedings requires the person to be heard. And so we will have to hear them,
Yes,
and inspection is required to be done.
and complete the proceeding with this.
Before inspection, hearing is being given or after inspection?
Inspection will be done.
Yes.
Firstly, my lord, we have to see whether according to sanction plan, G+1 sanction has been given or not. Sanction plan has been deviated or not. So inspection is required to be done. Thereafter, my lord, second floor. Second floor sanction plan is not there. If it is not there, we will call them for a hearing. Will they? If they do not show, we will then start proceedings under that section. It is automatic.
It would be taken.
But has not been taken.
The
regarding, I came from to know. Your Lordship, I came from to know your respondent number 6 already died.
Regarding this matter, I
Respondent number 6 already died.
Lordship, I came to know another suit walk up tribunal filed by the secretary.
So file application.
same, my lord, page 59 kindly. May I submit? I am appearing on behalf of.
One by one. Oh,
Page 59. Kindly see the order. Passed by the Honorable High Court. Number 2 and 3, Board of Waqf, Operative Court. দাঁড়াও আমাকে বলতে দাও ওয়াকফ বোর্ডে তো আজকে ডেট আছে is not maintainable before
yes,
this
yes,
আর দাঁড়াও না আমাকে বলতে দাও দর্শককে দেখতে দেখাতে দাও
yes, you.
On the basis of that section, page 52, Chief Executive Officer has passed this order, inquiry report. So it belongs to Waqf property. This, my lord, this High Court has no jurisdiction to try this. Already on the sensitive cause of action, my learned friend client filed a appeal before the Waqf Tribunal.
No.
And today is the fixed date. Today is the
file, Lordship. I know
My lord,
that
may I-
the appeal. Your Lordship respondent
And
is
section
died
33,
because
the Waqf Act.
Manna,
Dhara 33.
that son's name is Masum.
My lord,
Is
may
expired.
I submit the, my lord,
And Lordship's inquiry report not
fact and
inquired the
act.
work of land.
according to
You are appearing for
Board of Waqf. Board of
Waqf board. Yes.
Yes.
Last order.
According to the section 83 what? Yes. No any order passed by the Waqf board
Yes.
can be challenged before any other forum except the Waqf Tribunal. Right. This is the 83. Section 83. Judicial proceedings. Third time. আরে ওটা পুরাতন বই ছেড়ে দাও না তুমি
4 years past, your Lordship.
ঠিক আছে তুমি দেখাচ্ছ
Kindly see 2020 your order, your Lordship. Justice, perfect, your Lordship. Direction applicant to the respondent of the, to file an evidence, exchange of evidence. Still not just 4 years past.
law
Not
point
received any
বইটা দিন বইটা
Not able to receive, your
This
Lordship.
is the statute. This is
Not
the
required.
statute point of law. This is the statute. Is the pure question of law.
80?
83.
Yes.
Constitution of Tribunal. It is. Subsection what? The
Subsection 4.
No.
Subsection?
Subsection?
Subsection
One.
2. 1 and 2.
Yes, yes, yes.
The state government shall, by notification in the official gazette, constitute as many tribunals as it may think fit for the determination of any dispute, question, or other matter relating to a work or work property, eviction of a tenant, or determination of right and obligation of the lessor and the lessee of such property under this act, and that define the local limits and jurisdiction of such tribunals. So it is clear, any dispute, any question arose, or any against order passed by the board, that should be initially filed by the Waqf Tribunal. And so many judgments passed by this tribunal.
Totally pure COVID period. Kindly see, the order passed. Totally COVID period passed the work of board principle. And
Now functioning. Now it is functioning. Go and raise the question.
Okay, they will not raise the issue of whether any limitation is there.
Acquired of land, your Lordship, on the land.
Whether any limitation is there to file any dispute.
No, your lordships can direct.
To file any application before the Waqf board.
No. Your lordship can direct the petitioner.
Okay. You file. Tribunal, Waqf Tribunal.
My instruction is that
Tribunal file, may I file this?
Okay. Since a alternative remedy is available, so.
Kindly give a direction to file.
Several judgments passed by the Honorable Supreme Court as well as the our High Court. Anish Fatima, your lordships.
But it is what you are saying, that no such and such, initially you said no such and such court, that no court will not be High Court and Supreme Court. Yes. Okay.
Court, except tribunal initial.
Again, I am.
After that,
You hear? There may be some second thinking. 226, 32. It is basic structure of the constitution that cannot be changed.
may
Again, this is one day I express anger. One legislature, there is a judgment, one state legislature or central legislature, by passing a law or a act, cannot snatch away the power from the High Court and Supreme Court. Again, don't utter. I shall give you hearing. So the power under 226 cannot be taken away by the state legislature and central legislature. It is a constitutional provision. Now, subsequently, over the times, the concept of self-restraint has been evolved by the court. That the statute has made a prescription for alternative remedy. So don't exercise your power. But there is no complete bar.
Section 83, subsection 9. As per the High Court's direction, my lord, the kindly say I have pointed on
Okay.
page. My lord,
Since the statute has given.
Oh, my lord,
Okay.
section,
File.
section 80.
Stop that.
Section 9.
Asha, at the outset, your good name, please. Your good name, please.
Lordship,
Good name, please.
You are appearing for?
Mohammed Salahuddin.
Acha, Mohammed Item number 29. Yes.
ওইটা একটু দেবেন।
This matter pertains to refund of the,
Other side.
notice has been served, matter mentioned, and thereafter I am not finding the learned advocate does not receive the phone call at yet. Since 1 week I am not trying to. I am suffering since 2020. I am the auction purchaser. Purchase the land. Sale certificate has been issued, but position has not been given. 5 years.
Serve a notice after.
I have served.
You have served
Notice is
long
with
back.
me. No, just few days back also.
So file affidavit service.
All right, I shall file, but it will make it not today. I am trying to give another.
Okay, not today. I shall file.
Not to let it be not today. Simply not today. I am serving.
You
again.
give some handle to the court to
It is
proceed.
there. I have that.
To proceed expertly.
I have that.
Otherwise, yes.
I have that, but it is not
To the
evident.
learned advocate.
Yes, to the learned advocate. And yes, from yesterday I am ringing him. He is not receiving any phone call. I am trying by today. Another notice.
He is so powerful. He is avoiding you. You're receiving your phone call.
Let it be not today, but tomorrow. I am trying to bring him.
Okay, next. 30.
For the petition in this matter, my lord.
আচ্ছা আপনি এইটা হচ্ছে যেগুলো শুধু এই যে নট টুডে হচ্ছে সেগুলো রিটেন করবেন, বাকি সব নিচে নামিয়ে দেবেন একদম, বাকি একদম একটাও দেবেন না। যেগুলো শুধু নট টুডে হচ্ছে পিটিশনার প্রেজেন্ট থেকে আমি যেগুলোকে নট টুডে করছি আপগ্রেড, সেগুলোই থাকবে রিটেন ইজ পজিশন, বাকিগুলো সব নিচে। এইখানে দেখবেন যে পিটিশনার আছে, যেগুলো কোথায় গেল, যেগুলো পিটিশনার ছিল রেসপন্ডেন্টের জন্য টাইম হলো সেগুলো বাদ দিয়ে বাকি তলায় নামি। Yes.
Well, this is my affidavit reply against the affidavit in opposition filed by the respondent.
That matter?
No, this is another matter.
This is another matter, my lord.
Well, here what happened?
That matter, my lord, it
The-
was executive. This is
Oh.
non-executive.
Here what happened, my lord? The original writ petitioner. Here, my lord.
Recording in affidavit reply to recording in,
Here, my lord, petitioners are before your lordships now, presently the substituted petitioners. Now, here what happened, the original writ petitioner was an employee of my lord Eastern Coalfield Limited. Now, in 1992, there was a my lord few days absenteeism, and my lord the charge sheet was issued against him. Now, in 1994, he has been my lord dismissed from service in 1994. Immediately thereafter, my lord, I filed the writ application, and time to time order has been passed by this honorable court. My lord, I am coming to the annexures later on. Time to time the order has been passed by this honorable court, my lord, so that the case of the petitioner should be treated, my lord, leniently, and my lord, the order of dismissal is, my lord, the harsh punishment inflicted upon him for the few days of absenteeism. Now, my lord, in course of, my lord, during pendency, my lord, the original writ petitioner died. His wife and, my lord, the son has been substituted, and now they are proceeding this, my lord, writ application. Now, if your lordships kindly come, page 43.
So allegation is that unauthorized
Only.
absence. Unauthorized absence for how many days?
My lord, page 43, if your lordships kindly come.
43 years.
This is the
And
format.
18 February 2092 to
18 September 1992 till date means, my lord, July 1994.
15th July 1994.
This is the format charge sheet. This is also bad in the eye of law. A charge sheet cannot be format like this. No application of mine has been, my lord, used by them.
Now kindly see, my lord, there is a,
Can you challenge the same now?
no, I am coming, my lord. All this, my lord.
Earlier if petition
Yes, yes.
challenge, you
Yes, yes, I am coming, my lord.
despite such challenge being thrown, the learned coordinate bench, that has not entered, quashed the charge sheet.
No, remanded. Well, I am coming to that, my lord.
Remanded for what purpose? As you have submitted for choice of a lesser punishment.
Yes. No,
For
my
choice of a lesser punishment.
Lesser
That means it has certified or ratified up to the stage of passing punishment.
Very
Huh?
well.
Now he said that it is disproportionate. You consider it and give a lesser punishment.
My lord. Now,
Huh?
I am, my lord.
Now, in this challenge, the charge sheet was not in proper form. There is no form of charge sheet. No service jurisprudence prescribe any form or how there is no direction how charge sheet in a disciplinary proceeding would be issued in what form. There is no form. But laws is settled that what will remain in the charge sheet.
My lord.
Lordship is absolutely correct.
Now, my lord, page 47A is the first round of litigation. I am coming, my lord. The orders first, my lord.
You tell the fact first. Yes. First round of litigation you came after the appellate authority's order.
After dismissal.
After dismissal.
Dismissal.
You have
Now,
not preferred any statutory appeal.
no. Now, my lord.
Yes. Then
in,
what?
In,
what
1995.
Yes.
This honorable court directed the, my lord, petitioner to submit a representation before them, and they will pass the appropriate reason order. They passed reason order, reiterated their ground that dismissal is, my lord, the justified, and against this order, my lord, again I preferred.
Again you came.
Again I came.
That petition was disposed of.
Disposed of. That was the petition of 1990.
What is the direction?
My lord, that is very vital. Page 69.
Page 69.
It was the writ application of 1998. It was decided in January 2009.
Page 69.
69.
69 years operative part.
Well, may I read, my lord? It's required to be read, my lord. It is required to be read.
Oh, okay. You just tell the fact. Tell the fact means outline of the fact.
Well, here.
Thereafter, what order was passed at that time?
Well, same thing.
Undated order, such and such, the set aside. That means the order of the general manager rejecting the petitioner representation was set aside.
My lord.
As a general manager was directed to reconsider the petitioner claim with sympathy. It deserved. But in accordance with law, as early as possible within the time, if on de novo consideration, the point raised in the representation are not found acceptable, a reason order shall be passed in the event.
Now, my lord.
Consider a lesser punishment may be awarded, petitioner can be reinstated in service, it shall be opened. If petitioner is found to be physically fit or mentally alert for discharging duty, and so that an employee is required to discharge.
Now, during the period of
thereafter, what happened?
Yes, during the period of absenteeism, I was sick. The medical documents has not been relied upon by them, but Honorable Writ Court, the earlier round of litigation, my lord Justice Dotto was pleased to relate those documents, because in the disciplinary proceedings, your lordship knows that in a case of unauthorized absenteeism, the inquiry officer has to satisfy that the absenteeism was willful and deliberate.
Yes, everyone says so.
My lord. Now, the medical documents I have
reconsidered. The matter was sent to the authority for reconsideration.
Reconsideration for lesser punishment.
With sympathy.
Sympathy and lesser punishment.
With sympathy, it deserved, but in accordance with law. I see. Now, whether they imposed any lesser punishment?
No. Again, my lord, page 81 to my lord 83, kindly come.
83, yes.
83. Fact remains, barring period such and such, owing to the sickness or revolt CO number such and the petitioner was absent from Atto, and there is no supporting medical documents against the period from such and such. such that it can be treated without any reservations or preconceived notions that the inclinations on the part of the petitioner to perform his entrusted duty is doubtful.
Okay,
No.
they dismissed.
This way
Again.
again.
Ah.
Now, here, my lord,
this
the,
time
though
what
the
happened?
writ court has, my lord, accepted the medical document because there was a treatment in their own hospital. That has not been accepted by them. Now, again, my lord, I filed the writ application challenging that, page 88. In 2009, I challenged, that was decided in 2019.
To reconsider matter, passer is in order.
In light of
that the designate of the and the person equivalent to the Demeter will consider the passer.
In light of that order, 2009 order.
Acha. 2009 order. In the light of the order dated such and such. Okay.
Now, my lord, in 1990, in page number 95.
More than 1 year, 10 months, we did not take it necessary to send even one intimation to the unit management. Thus, reconsidering the decision on the quant of assessment, the undersigned is handicapped to review the punishment in absence of any specific count, be it for sickness or otherwise. Again they rejected.
Again they rejected.
And you have come challenging that.
Challenging that. Now, first thing, my lord, the charge sheet was issued.
They are saying that you have not, although you said that the absence was not delivered, and you, due to your sufferance from any illness or such and such, due to on illness, ground of illness or anything, you could not attend. But whether you produce any document before them.
Yes, that's why, my lord. If your lordship kindly come.
For them means during the proceedings.
Huh?
Before us means during the
page 69 is very vital, my lord. May I read? That's why, my lord, I wanted to read that judgment, my lord. May I read? It's very. The petitioner was an employee by the respondents on compassionate ground. Since his father died in harness, the appointment was given to him on 27th March 1989 by the senior personal officer of Eastern Coalfield Limited, North Searsol Colliery under Kunusturi area in the district of Bardhaman. The petitioner fell sick and accordingly was admitted to hospital. It appears that during the period 92 to 93, he was under medical treatment. It is not disputed that the petitioner was discharged from hospital on and from 6 January 1993, and he was stayed at his native village. It is the case of the petitioner that after being discharged, he had suffered from the various other ailments and he became an epileptic patient. It is the further claim that due to such ailment, he could not attend the office. The petitioner had not given any intimation to his employer that because of his suffering, he was unable to attend office. A charge sheet dated such and such was issued by the agent manager, North Searsol Colliery. The petitioner was charged under section such and such of industrial standing order. He was called upon to show cause within 44 hours as to why the disciplinary actions would not be taken against him. The petitioner did not reply to the charge sheet, purportedly on the ground that he did not understand the English and none of his fellow villagers understand the language. However, he participated in inquiry that followed. It appears from the inquiry report that he was given opportunity to cross-examine the witnesses produced on behalf of the management, but he declined to cross-examine. He, however, admitted before the inquiry officer that he did not report his sickness to the colliery authority since he failed to produce any document regarding his treatment to prove his illness, and the management had produced paper to show that the petitioner had remained absent without authorization. The inquiry officer held that the charge proof against the petitioner. By the order dated 1994, the general manager of Kunusturi area dismissed the petitioner from service with immediate effect and directed him to collect his dues after observing necessary formalities. Questioning the order of dismissal from service, the petitioner invoked the jurisdiction of this court by filing of the writ application in 1995. The writ petition was disposed of by order dated 1995, granting leave to him to file a representation before the authority concerned within a month, and it was directed that if such representation is filed, the authority shall consider and dispose of the same within a period of 4 weeks from the date of receipt thereof. Considering the fact that he was ill at the relevant point of time and was confined to hospital, the petitioner was duly filed a representation availing to the leave granted by this court. In the said representation, the petitioner narrated how he was prevented from giving reply to the charge sheet and to raise the effective defense in the inquiry that followed. He, however, categorically stated that after his discharge from hospital in January 1993, He developed epileptic symptom and being a member of weaker section of the society had no means to be treated by a doctor, and he is not in the lower sutra of the community to which he belongs. He had been subjected to treatment by Ojha and had since recovered. He had accordingly made a prayer for reinstatement in service on revocations of the order of dismissal. The general manager of such and such, upon granting the petitioner an opportunity of hearing and purported consideration of his representation, maintained that the final order of dismissal holding inter alia that the same had been rightly passed. In arriving such findings, the general manager observed that the petitioner had not produced any certificate or papers to show that his sickness contained in dated such and such when the charge sheet alleging unauthorized absence was issued to him. It was also observed by the general manager that the petitioner, though residing at a place near to the collier in question, had not sent any information regarding his alleged sickness for the period from such and such, and therefore he was satisfied that the petitioner was not interested in retaining his service. The entire disciplinary proceedings as well as the undated order of general manager rejecting the petitioner representation are subject matter of challenge in the instant petition. At the outset, Mr. Mojumdar, learned counsel for the respondent, contend that petitioner has not availed the alternative remedy provided under the Industrial Dispute Act, and therefore this court ought to negate him to the alternative forum. According to Mr. Mojumdar, even if the domestic inquiry had not been fairly conducted, the respondent would have a further opportunity of establishing the charge before the Industrial Tribunal. Accordingly, the court may not deprive the respondents of such opportunity. Since the writ petition was filed in the year 1998 and 11 years has already been passed since then, this court considered it improper to accept the preliminary objection of Mr. Mojumdar and proceeded to hear the writ petition on merit. Mr. Rai, learned counsel for the petitioner, raised the following points. The charge sheet disclosed close mind of disciplinary authority. The petitioner was given 48 hours to reply to the charge sheet, which is inadequate. The fact that the petitioner was admitted in the hospital from 90 to 93 was within the knowledge of the respondent, and therefore the charge sheet alleging that the petitioner had remained absent without authorization from 1992 till some date is defective. The petitioner not given opportunity to engage a co-worker to assist him during the inquiry, and punishment imposed is strongly disproportionate, and there has been no proper consideration of his representation. Having perused the charge sheet issued against the petitioner, this court is unable to uphold the contention of Mr. Rai that the same has been issued with a close mind. The allegations appears to that the petitioner had absented from duties in 1993 till date of issuance of the charge sheet without any information authorization.
Okay, Mr. Ghosh. My lord. Okay, yeah. Yeah, I'm coming to you. So, Mr. Das, that page number 77 at least held that the petitioner's claim should have been reconsidered with sympathy. Court observed that the petitioner deserved and court indicated that even on de novo consideration, the point raised in the representation are found not acceptable. Yes, a reason order shall be passed. So petitioner admittedly was hospitalized for a period.
No, that's my case. He has nothing to show. Even in this petition, your lordship will not find a scrap of paper in support of the contention what Mr. Ghosh is making. Let Mr. Ghosh make his submission, my lord. I will open up my case.
No,
I have
Mr.
to show
Ghosh, far from
because, my lord, as on date,
far from a page number, take that he is hospitalized for a certain period. Take me. Okay, that apart.
my lord, it's a 22 months. 22 months absence. I will show the relevant judgments also. I am couched with the citations.
May I read the entire judgment, my lord?
But entire judgment, I will also read the entire judgment. That's the bone of this entire matter,
page-
this judgment.
Page 73, my lord, if you will kindly.
Nothing remains, my lord, save and except that disproportionate punishment, that theory, my lord, proportionality.
And
Nothing remains as on date.
apart from
Let-
this,
let
the
it
charge
be
sheet,
not agitate because of this.
apart from this, my lord, the charge sheet was issued.
Cannot.
Charge sheet was issued for the purpose of minor penalty. They have issued the major penalty. I am coming to that point, my lord.
Right.
I am coming to that, my lord. Because there was a remand made by this honorable court to pass the order in accordance with law. It was their duty to verify whether the charge sheet was issued for the purpose of minor penalty or major penalty. I am coming to that, my lord. Page 73, if you will kindly come.
Yes.
The fact that the petitioner was admitted in hospital from September 1992 to 6 January 1993 is within the knowledge of the respondent, and therefore the charge sheet alleges that the petitioner had remained absent without authorization from 92 till date. Of its issue is defective. That was the submission. The petitioner was not.
Yes.
Yes. The petitioner was not given opportunity to engage a co-worker to assist. Having so 5 point was considered by this my lord, honorable single bench at that time. Having perused the charge sheet issued against the petitioner, this court is unable to uphold the contention of Mr. Rai that the same has been issued with close mind. The allegations appears to be that the petitioner had absented from duty from 1992 till date of issuance of the charge sheet without any information authorization causing company's work, dislocation of the company's work and inconvenience to fellow workers. It passes the court's comprehension as to how such a charge sheet could be said to have been issued with a close mind. The allegations was that of the absence without authorization information, and therefore no illegality is found in the wordings of the charge sheet. The contention that the petitioner did not have adequate opportunity to read the charge sheet, to reply the charge sheet, although attractive in the first brush, does not impress the court on scrutiny of the development during inquiry. It is no doubt that the giving 48 hours to a illiterate employees like a petitioner to reply the charge sheet which is leveled against him in a foreign language is inadequate. But this ipso facto would not enable the court to hold the proceedings, would fall through only on this ground. The petitioner could have, after receipt of the charge sheet, prayed for extension of time. Even he could have replied to the charge sheet prior to his participation in the inquiry. Having not taken recourse to such of the kind steps and having participated in the inquiry without raising demur that had been prejudiced by the reason of non-grant of sufficient time to reply to the charges, it has to be held that he waived his right to have more time. On overall assessment of the proceedings of inquiry, it does not appear that the petitioner was denied reasonable opportunity to contest the charge, and therefore this court is unable to hold the inquiry to be vitiated on this ground. Further, mere fact that the respondents had knowledge of the petitioner's admission in the hospital during 92 to 93 rendered the allegations contained in the charge sheet defective, which in the third contention is equally without merit. By applying the doctrine of severalty, this court would hold that the petitioner was accountable for the period from 1993.
Yes. From 6/1/1993 to till date of issue of charge sheet.
Issuance of the charge sheet,
There being no
sufficient explanation
furnished
furnished by him
regarding his absence during that
during
period,
such period.
inclusion of the period in the charge sheet would not vitiate the order of
penalty passed on
penalty
inquiry against him. My lord. Now, the applicable rules governing the inquiry permits a delinquent employee to obtain assistance of the co-worker to assist him in the inquiry. According to Mr. Rai, the petitioner was not allowed such assistance upon consideration of the applicable statutory provision. It appears to be in an enable provision, and therefore the petitioner could well have avail of the right that is conferred on him by praying the engagement of the co-worker to assist him in the inquiry. It is not
actually the court held that the punishment was
disproportionate,
and hence it was sent. Punishment must be commensurate with the gravity of the misconduct.
Court also, my lord, subject to correction. Court did
My lord,
not
may I
held-
complete? My lord, may I complete?
I will not interrupt you. Court also did not hold that it's disproportionate. Court said, as thinking about his stature, that workman's stature, you reconsider it sympathetically.
Now, why, if the court does not come to a conclusion that there is a scope of reconsideration,
Yes, obvious.
it would not be sent back.
Not at all. Could not. be.
So court considered that there is a scope of, or there is a requirement for reconsideration. That means the issue is to be revisited.
My job
Since
today,
there is a certain aspect which has not been considered.
my job today before your lordship
Okay.
would be, your lordship is absolutely.
Actually, problem in one judgment I stated, dismissal is a capital punishment. In penal provision, capital punishment, you know, death
Dismissal,
penalty,
removal,
thereafter,
compulsory retirement.
life imprisonment.
Yes.
But we have a guideline. Okay, we are lucky enough that we have a guideline. We can get a guideline when to choose the death penalty, when to choose the life imprisonment, and when for any other
Lesser punishment.
But this guideline is not available to an officer who suddenly started acting
why
as a disciplinary authority.
That's why on the last occasion also your lordship was
Yes.
saying the preponderance of probability.
That is another preponderance
Because
of
based on that,
probability.
no, it
degree
will
of
come, my
proof.
lord. Degree of proof, it will
Here,
come. Why?
quantum of punishment.
Yes.
In criminal proceedings, you hold that is you convicted under the provision of 302. Next, the question of sentence will come. Whether I send it to award you life imprisonment or death penalty. A court is to decide. Now the question of. Now, after holding that yes, inquiry officer report, yes, okay, I agree with the same, and you charge proof, then question of choice of punishment will come. There are many major penalty. Now, which would be appropriate?
Depending on the gravity of the misconduct. Alright, as like they are also my lord, in the criminal proceedings, it's depending on the gravity of the
In
crime.
one judgment, I was compelled to write, I don't know, that there are no guidelines available to the person who is acting.
Guideline, my lord, so the guideline is considered.
Actually, one thing, whether it would not be appropriate to retain this person in service, whether the circumstances suggest this, then I can choose disciplinary to go.
Lordship is absolutely correct.
Or the conduct is so grave that is unbecoming of a government employee or a employee of this institution.
Prudent employee.
Yes. You are not at all entitled to become an inquiry. That means the situation will be so grave.
Yes.
Then capital punishment.
Yes.
That is dismissed.
And that's the gravity, my lord.
Dismiss means not only removal the person from your establishment, you are disqualifying this person from getting a further employment. Okay, that you will not get any further employment. As and when he will offer his candidature before any institution, a past record, dismissed, no one give him service.
Has to.
That means you are snatching away his further way to earn his livelihood. A grave punishment one.
Yes.
Whether the circumstances at hand of this case
calls for the same or not.
It says so.
Yes. That's
yes, he has. You consider. I shall not allow him. Constructive res judicata will apply against him. This point that the charge sheet was issued for minor penalty, constructive res judicata will apply. Mr. Ghosh will say, why I am not, I am coming to this point only. Constructive ought to have raised.
Yes.
Now the question of quantum of punishment has come.
Is only that much.
You ought to have raised explanation 4, section 11 of CPC.
Now,
ought to have been raised.
Now, what
So
thing is,
constructive res judicata will come.
as to
Now
why,
come
as
the
to why,
question of
the Honorable, my lord, earlier read court directed, my lord, them to reconsider. Because Honorable Read Court accepted that the charge sheet was issued only for the purpose of minor penalty. I am coming to that, my lord. Apart from this,
Okay, so
that
the honorable court, honorable coordinate bench directed that you consider this point also.
and my lord,
That means that point was kept open.
yes, the one was kept open because there was a mandate given to them. Or may I read the entire? So fact will be clear. Two pages are left. 2 pages, my lord. The applicable rules governing the inquiry permits a delinquent employee to obtain assistance of the co-worker to assist him in the inquiry. According to Mr. Rai, the petitioner was not allowed such assistance upon consideration of the applicable statutory provision. It appears to be an enabling provision, and therefore the petitioner could well have avail of such right that is conferred on him by praying for engagement of a co-worker to assist him in the inquiry. It is not improbable that the petitioner may not have known that he was entitled to the assistance of the co-worker, but on wholesome appreciation of the facts of this case, this court is of the considered view that even if he had been allowed the assistance of the co-worker, the same would not have been established his innocence, since it is an admitted position that the petitioner did not send any intimation to the colliery authority during the period he was absent. The charge having been established by reasons of non-production of the material document for which the onus lies on the petitioner, this court is unable to accept the contention of the petitioner. The last contention of Mr. Rai, that the punishment is disproportionate to the gravity of the offences committed by the petitioner, coupled with the fact that his representation has not been duly considered, however, has impressed the court during the 3 years the petitioner was in service. There had been no allegation of unauthorized absence. The cause of action giving rise to the charge sheet from his ill health, the petitioner being a member of weaker sections of the society has to fight for his survival. In a case of this nature, the attitude of the disciplinary authority should not have been that of that hard taskmaster. Kindly note this, my lord, part. The cause of action giving rise to the charge sheet resulted from his ill health. This is a very vital part, my lord.
You are reading from page 76?
76.
Yes. Hard taskmaster.
The petitioner,
Some amount of leniency could have been shown.
the petitioner being a weaker section of the society has to fight for his survival. In a case of this nature, the attitude of the disciplinary authority should not have been that of hard taskmaster. Some amount of leniency could have been shown. The petitioner, having in his representation narrated the fact that he had been treated by Ojhas at his native village, which is not uncommon. This is the case of 1992-93. The petitioner, having in his representation narrated of the fact that he had been treated by the Ojhas at his native place, which is not uncommon, and for which obviously no material papers could be available to him. It was incumbent on the general manager to consider the claim for reinstatement of the petitioner on revocation of the penalty, keeping in mind this aspect. Kindly, my lord, see the observation. However, the general manager appears to have been proceeded mechanically, holding that the petitioner did not produce any document paper in support of his contention that he was sick. To expect the petitioner to produce the paper of being treated by Ojhas is asking for too much. Since the general manager has not considered the representation of the petitioner in the proper perspective, this court is of the considered view that ends of justice would meet if he is directed to reconsider the decision of the quantum of punishment to be inflicted in respect of the charges that has been found to have been proved against the petitioner. It is ordered accordingly. The undated order of the general manager rejecting the petitioner representation thus stands set aside. The general manager is directed to reconsider the petitioner claim with the sympathy it deserved, but in accordance with law as early as possible, but positively within a period of 6 weeks from date of receipt of this order. If on de novo consideration the points raised in these representations are not found acceptable, a reason order shall be passed and communicated to him immediately. Thereafter, in the event the general manager, on due appreciation of the plea of the petitioners, considers that the lesser punishment may be awarded and the petitioner can be reinstated in service, it shall be.
This part I have read.
So this is the fact has been
dismissed from service.
Dismissed from service. in 1994. Thereafter, in course of this, my lord, writ petition, my lord, pendency, my lord, he has died. Now only, my lord, one judgment.
Actually dismissed for service, Mr. Das. Yes, he
lord,
lost his benefit of past service also.
Everything.
It has to be,
Everything.
if the situation is so grave, we have to, my lord, that I will prove, my lord. How far it can be gone into? or
Now,
not,
paragraph,
where is
my lord,
the
may I complete
check?
then, my lord, may I complete, my lord? May I-
Yes, I have read the order.
No, my lord, another, my lord, point, my lord, I would like to raise.
Mr. Ghosh has
Yes,
so many-
take the point, take the
My
point.
lord, now,
Now I have 700 matters, Mr. Ghosh.
It will not be completed today, my lord. It will take another day at least. It will take another day because I have to show certain paragraphs, many things. my lord.
Well, if you will kindly see the schedule of delegation of power.
Yes.
Annexed.
No.
So if it is not annexed, my lord, then I have to go through it, my lord.
Page 43, before that, my lord, if you will kindly
My
come
lord,
page
that date,
43.
he is required to tell me, my lord, which.
Delegation of power of Eastern
No, no,
Coalfield
date,
Limited.
date.
এখানে date না, delegation of power of কি date?
No, no, delegation of powers are, there are several delegations, one after another came. I do not know which he is showing.
No, I have the one copy, I don't know.
Cannot be, because from, it's in 2001, there is in 2004, there was also a delegation of powers. So whether at that point of
Okay,
time.
let my learned friend reply to that, my lord. Let me
No,
complete my submission.
Hey, my lord, of which date he is showing?
The delegation of power, this is a book, there is no date. This is not
Delegation
letter.
of power, what?
Of Eastern Coalfield Limited. There is no, this is not letter that would be the date. And this is not the, my lord, law
cannot
made
be
by
the-
the parliament with a certain date. There is a book and I find from the book, I can serve the copy to him, my lord.
Let him serve.
Let him, my lord, check.
Let him
Delegation I couldn't follow. Delegation of power.
For inflicting the punishment and starting of the disciplinary proceedings in respect of the, my lord, punishment. I am coming to that, my lord. Kindly come page 43, my lord.
But
I
I
will
do not-
conclude today or
I will conclude, my lord. I will conclude today. my lord.
421.
Yes, I have for 5 minutes, my lord.
5 minutes.
Well,
Okay, very good.
Page
Welcome.
43.
Page
43.
43. Yes.
Well, kindly see, charge sheet has been issued by the manager
By the manager, yes.
at bottom.
Yes, manager.
Now, my lord, kindly come, my lord, this delegation of power.
Yes.
At first page, CGM, GM of the area. Then, my lord, first page of this delegation of power, my lord.
Oh. Yes.
CGM, at my lord, the top, my lord, the heading. Nature of power at left hand side. Then CGM, GM of the area at middle. Then agent. Then, my lord, colliery manager. Right hand side. Lords, you got it, my lord? Now, kindly come last page.
Yes.
Disciplinary actions in respect of employees for whom he is the appointing authority. Then kindly come, my lord, thereafter, my lord, full powers to take disciplinary, that is in respect of the general managers. Full power to take disciplinary action, including removal, termination of service, and other minor penalties in accordance with the prescribed rules, such and such, and such. So, in respect of major and minor penalties, the disciplinary proceedings, this disciplinary authority is the general manager. Here, the charge sheet has been issued not by the agent, by the manager. Manager, GM, then agent, then manager. Now, right hand side, if you also kindly see middle, full power to take disciplinary action except dismissal. Against wage board employees under his administrative control and in accordance with the prescribed rules, / standing orders. And last category, full power to take disciplinary action except dismissal against all employees in wage board categories in accordance with law. So, the charge sheet was, my lord, issued either by the manager or agent. If I accept, my lord, either one, even then they cannot, my lord, impose the penalty of dismissal. that was issued only for the purpose of imposition of minor penalty, because that was not the case of fraud or dishonesty or, my lord, any heinous crime. That was only for the purpose of, my lord, the first time occurred due to the sickness, the unauthorized absenteeism. He is not the habitual absenteeism. Now, I will conclude, my lord, very fast. One paragraph I will read.
Yes.
From the judgment of the Honorable Supreme Court,
Yes.
paragraph 18. I will hand over, my lord. In departmental proceedings.
Doesn't Mr. Ghosh think citation is to be?
Yes, certainly. 2012.
Not saying anything.
Citation 2012.
2012, volume 3, SCC 178 page.
Yes.
Paragraph 18, my lord, kindly see.
Have you read? Have you got one copy?
Yes, 2 copies.
Oh. At least you have brought one for me.
No. I have.
Yes. Yes. 18. In
Paragraph 18.
departmental proceedings, allegation of unauthorized absence for duties made, disciplinary authorities required to prove the absence is willful, and in absence of
Findings, the absence will not amount to misconduct. Even this absence was accepted as not willful by the writ court, and let this show from their, my lord, inquiry proceedings that there was a specific finding that the absenteeism was willful. So this is not misconduct at all, if they cannot show that the absence was willful.
Okay, para
18.
Para 18.
Here also the same circumstances, the medical papers, etc. I can read, my lord, entire thing. I am not, my lord, excuse me, my lord. I know that your lordship will, my lord. And another judgment for full back wages. That if the termination is bad, and if it is occurred due to the,
Bhai or yeah.
no, the mother Dipali Gundu. Dipali Gundu.
Dipali Kundu.
Thereafter, there are, my lord, based on this judgment.
2020 Justice.
Yes.
Chandrachud being that judgment.
Based on this judgment.
Dipal Sir, all considered in that judgment.
2013.
Raja Bhai Sachan Sar judgment. 2020.
2013 10 SCC page 324.
2013 SCC.
SCC page 324. Here may I read, my lord, the relevant
judgment. Raja Bhai Dipali Kundu, Gundu Swaras, yes. It is here. There is a judgment, latest judgment.
Here, my lord, my fact is better than this Dipali Gundu. As to why, there was already an order passed by the writ court that has not been complied in his, my lord, proper perspective.
Payment of back wages will come when you will be reinstated.
Yes.
Question of reinstatement will come later on.
My lord.
When they will impose the minor penalty and will reinstate you.
Now, my lord, thing is,
then question of payment of back wages comes only when there shall be a reinstatement.
Reinstatement. Here, my lord, reinstatement is not possible because person has died during pendency of this writ application, present writ application. So, my lord, he will be treated as in service with minor penalty, if possible, and, my lord, the entire benefit has to be given. Because this was the fault caused by them since at least from 2009, when the writ court has passed the order like this of my lord Justice Dipankar Datta, as his lordship then was. Now,
okay,
I could have, my lord, worked at least from 2009. Now, my lord, the very relevant paragraph, may I read?
Okay, yeah, Dipali Gundu not required to be read. Okay, relevant paragraph, yes, paragraph you tell. Paragraph,
my lord, paragraph 38.5, the cases of the competent court tribunal that if employee acted in gross violations of any statutory provisions, unlawfully or the principle of natural justice, or guilty of victimizing of the employee or workman, then the court or tribunal concerned will be fully justified in directing the payment of full back wages. In such cases, the superior court should not exercise power under Article 226 or 136 of the Constitution and interfere with the award passed by the labor court, etc., merely because there is a possibility of forming a different opinion on the entitlement of the employee of the workman to get full back wages, or the employer obligation to pay the same. The court must always keep in view that the cases of wrongful illegal termination of service, the wrongdoer is the employer and the sufferer is the employee workman, and there is no justification to give a premium to the employer of his wrongdoing by relieving him of the burden of pay to the employee workman his duties in a form of full back wages. Here the case is a severe violations of the court order, and time to time I approach before this honorable court. Thereafter, my lord, twice. After that order, my lord, I have to approach before this honorable court twice. Even, my lord, in the last round of litigation, my lord Justice Kapoor directed them to comply the order strictly passed by this honorable court in the writ application of 2009, which I have read. Even then, they have reiterated their same ground time and again. And by this time, this gentleman, my lord, having no food, medicine, nothing. I am not going to any sympathy issue, but this is a fact. He had died. And all the children were, my lord, in a labor, doing, my lord, the Toto Pular now. Central government employees, son.
Central government.
Yes, PSU employees. And wife, the petitioner number 1 is now is the maid servant of someone in the local area. This is the situation.
That's all. Mr. Ghosh, learned advocate, representing the petitioner, has
My lord, my lord, kindly, my lord, because your lordship has already spared, my lord.
Shows, my lord, not before puja. My
No, even
experience
then, my lord, because
But on
my lord,
6
twice the determination.
Your learned friend does not want and hence.
No, I
My lord, because your lordship this case, my lord. Market part, my lord, special.
I don't.
My lord, make it.
If your lordship, these matters,
As
I don't mind.
as jointly played by the respective